preparation if a trial becomes necessary, based on, I haven't heard all these motions, and some of them are definitely dispositive. So, all right, welcome everybody. So they're out doing that when they come in with the monitor. I mean, my proposal is to just get going. If that's okay with you, I'm going to defer to the folks that don't have the monitors. Are you okay starting, and then we'll take a break while they set some things up?
I think until somebody's speaking on the screen, we're fine to do.
Yeah, okay. I understood also, everybody who's speaking today is here today, right?
Maybe not. With the court.
Let me rephrase that and take the question mark off the end. Everybody who's speaking is here today, period.
Okay. I'd just like to approach it this accordingly.
Okay, fair enough. We had a brief scheduling conference with the attorneys.
Your Honor, can I interrupt this quickly? My client is on Zoom.
Hold on a minute.
Can I get your name, please? My report on that, Francis Carroll.
Yeah,
It doesn't show up, but
no,
What is your client's name?
Miss Bentley was trying
Is he
to
Frankie?
change his name because it was up as Frankie.
Is he Frankie? Right, because we're not going to let folks willy-nilly into the Zoom, especially since we're live streaming. And as you said, I think we discussed this on Friday, do our clients need to appear on Zoom if they're not going to appear in person? And I said, yes.
And there was some question after that to us. Does that apply to non-full
No.
defendants?
It's the four.
Thank you.
So we did come to, we have 57 motions. We've got the week set aside, and depending on how it goes, I don't know. Whose is this? I'm gonna move this so I can see what I'm missing. I'm not trying to mess with your audio, sir. Well, I got so much room up here. So this is 23 SC 189192. State person, we have 61 folks. I'm not going to read out all 61. But on today's calendar, we have Francis Carroll, James V. Mariscano, Alexis Papali, and Spencer Blair. And I have Schwartz. I don't know why it's still showing up as Mr. Dejanon for Mr. Mariscano, Mr. Hetzel for Papali, and Mr. Kazicki for Liberto. And the first motion we have demurs. The first one we have up is Papali's motion to have defendants demurs is to count one, all of them heard. We're gonna hear the four that are here. So the first one I have is Papali's general and special demur to count one of the indictment. So Mr. Hetzel.
And I apologize, before we begin, can we just ensure that each defendant is on Zoom? I see one that says Frankie's, I assume that that's Mr. Carroll. I can't tell anybody else just from my screen. I don't know if anyone else can see them. I can't.
Fair enough, fair enough. Do we have, Mr. I see, is Francis Carroll, is that Frankie?
Yes, Your Honor.
Can I get him to turn some video on, please? Is Mr. Mariscano here?
Yes, my client is.
Please stand. Thank you, sir. You can have a seat down. Mr. Papali?
Here, Your Honor.
Thank you, sir. And Mr. Liberto?
Yes, Mr. Liberto.
Thank you, sir. All right, and I see lots, I have a full jury box. I'm sure one or the other of these parties would love to have that jury. But first off, we have Mr. Papali's general and count one. So, Mr. Hetzel, the podium is yours, sir.
Thank you, Your Honor.
And Mr. Papali does need to turn his video on.
Mr. Carroll, Judge.
Mr. Carroll, I'm sorry.
Passing that message.
Okay. Well, I thought I was passing it by, staring at the screen saying, Mr. Carroll, turn your video on.
And while we're waiting, Your Honor, may I go through rule of sequestration for any future witnesses?
Absolutely. Thank you, Mr. Carroll. If there are there any witnesses that are going to be testifying? Mr. Hetzel?
Not for such, Your Honor.
Okay. I'm just going to go down the line. Mr. Kazicki, you going to have any witnesses?
No witnesses, Your Honor.
Mr. Dejanon?
Yes, Your Honor.
All right.
And I can ask them to step out.
Mr. Schwartz? No, you don't ask him. I tell him. Okay. If you are intending to be called as a witness in this trial or in this hearing, I'm going to ask you to leave at the present time. Do not discuss your testimony with anyone outside in the hall. Once you have completed your testimony, you are free to remain or go out about your way. But if you do go out and about, I'd ask that you not discuss your testimony. When I say ask, I mean I'm telling you, do not discuss your testimony with anyone. Thank you very much.
And if I may, Your Honor, I'm waiting for a witness. I don't know if she's here. I could call her. I just never met her in person, so I'm not sure if she's here. Is Miss Paige Singer here? And that's all my witnesses.
Okay, all right. The rule has been invoked. All right. Mr. Hetzel.
Good morning.
Good morning.
For a point of clarification, are we skipping my motion to have all general demurs and special demurs as to count one heard before my client's trial?
Yeah, I am hearing y'all's for. That's what I'm doing. I kind of let everybody know that. Now, with the understanding, because we have 200 and some odd predicate predicate/overt acts. Mr. Schwartz was kind enough to go through each and every one of them in his motion. So I have seen that, and each, your clients are named in some, and other folks are named in others, and whether that ties in and provides sufficient nexus, etc. We'll cross those bridges when we come to it.
And then additionally, we did file specifically joining two general and special demurs, one filed by Attorney Samuel and one filed by myself.
I see Mr. Samuel here. Lovely reading of the Kimbrough case. Thank you very much. I also have your, for the record, Mr. Samuel had his heard in front of Judge Adams, and I believe the order was issued in April, March. Mr. Samuel?
Judge Adams' order was entered the day that we had our initial appearance with you.
That's right, in May. And you have filed a motion for reconsideration.
It's both reconsideration and the note that most of our issues were not addressed in her order, so it's really going to be heard for the first time.
Well, I've read the transcript, so it won't be heard. I've read the transcript.
Okay.
So, go ahead.
As to our demur filed on behalf of my client, Alex Papali, we specifically want to point out a date range issue, which is that we demurred to the count one as being imperfect in substance and form, because the state provided a date range which preceded the acquisition by the city of Atlanta of what would eventually become the training center, which we believe is the crux of this case.
Can you pull that microphone up closer to you, please?
I can't, does this help?
Hold on one moment, Mr. Hetzel. I can't connect. please coordinate with our folks because your sound equipment is affecting his ability to do his job. When you two try your microphone around our microphone, he gets nothing but feedback. So I see a mic wrapped around Mr. Hetzel, and I know this is none of you're doing. No, you see where there's a microphone wrapped around the microphone right there?
Oh.
Yeah, whose microphone is that? Anybody going once? That's yours?
Yes, sir.
Fix, please. He's gotta be able to do his job. Now, Mr. Hetzel, you were saying, the date range provided by the state predates the acquisition of the land that is the gravamen of this indictment.
I was your honor.
Okay. And do you have, just for the court's curiosity, what date was that land acquired on?
So the indictment dates the beginning of the criminal enterprise or the alleged criminal enterprise to May 2020. However, it was not until the following year, September 2021, and I will provide the court with a URL link, which is tinyurl.com/tinyurl.com/tinyurl.2 actually timeline that ultimately resulted in the land swap, which began the process of construction of a training facility. And as I am pointing out in paragraph 4 of my general and special demur section, exists only if the state presents evidence that it cannot reasonably narrow the date range. There are other cases that I may bring up, but at this point I will turn it over to the state to see if they have a witness who could provide evidence that they could not more reasonably narrow the date range.
Mr. Fowler? Or, I'm sorry, I don't know which one of you's handling this one. Is this gonna be you, Mr. Fowler? Or?
There are a lot of things that overlap in these arguments in the demur, so that's all.
Judge, as to the first allegation or assertion that the defendant makes in this regarding when we allege that the conspiracy began or that the enterprise began, I'm just gonna point out that that's really, their argument is really is can we prove what we've alleged? And so, because we're here on a demur, what did we do? We said in our indictment that, based on the evidence that we have, the enterprise began in 2020, in May of 2020. Now, how are we gonna prove that? That's really not a question for demur. I'll go ahead and tell the court though that we believe we will be able to do so. In fact, I can throw out a couple of facts for the court. One, there was a co-conspirator that said it began in 2020, in that summer, around that spring, May-ish. And two, the Networks for Strong Communities, which is thoroughly alleged in the indictment as the funding source and part of the organization of the enterprise, actually was incorporated in August of 2020. So basically, Judge, the issue of how are we going to prove that it began that early, it's an issue for trial and not an issue for demur. Additionally, the other argument they made, Judge, is, excuse me, my notes. is whether we sufficiently narrowed the date range. And I'm just gonna point out, this is gonna overlap, and I hate doing it this way, but the reality of it is that in one situation and out on one side of their mouths, they're saying you have to prove continuity, which means you have to prove years and years and years of racketeering activity. And on the other side, they're also saying, but you didn't narrow it enough. And those two things are completely inconsistent. We have narrowed it according to when this conspiracy began and when they got indicted. That's all we have to do. We have to prove, well, we do have to prove, not continuity, we do have to prove a pattern of racketeering activity. The allegations in this indictment, not proof at trial, the allegations in this indictment thoroughly establish and set out how the pattern of racketeering activity began in, or the enterprise, began in 2020 and continued on through 2023. The case law cited by the defense has nothing to do with RICO. The case law that I've seen cited by the defendants in this case, multiple defendants in this case, about narrowing the date range are child sex abuse and incest cases. Completely different factual situation where the courts have said, no, you can't argue a pattern. You have to specifically allege, essentially. And what we've got here is an affirmative obligation on the part of the state to allege a pattern, which means a course of conduct over a period of time. And we didn't determine how long it went on. In fact, we would have much rather it go shorter. They determined when it went on. We specifically alleged, as overt acts and predicate acts, with particularity, different dates that different overt acts and predicate acts occurred. So Judge, we are not, the state's position is we absolutely cannot narrow the indictment or the conduct to a narrow or a more specific date and time because their activity spanned this entire period of time, and these specific dates of particular overt acts and racketeering activity are alleged in the indictment.
Okay. So, to me, that sounds like, well, the Department of Public Safety building or the training facility is a large portion of this indictment. It is not the only thing in this indictment. Therefore, they are saying we're not bound by when that land was swapped or acquired. We have a date range that we gave you, and that's the date range we're going to have to prove.
And allege, yes, Judge.
Well, allege and
Yeah.
prove.
And prove, yes, initially, yes, yes.
So they're saying the conspiracy is bigger than just what happened with the land and the land swap.
Well, and Judge, understanding too, Mr. Fowler can probably speak more to this because he was involved at the outset of this a lot more than I was, to be completely candid with the court, and has more knowledge, about the inner workings of it and how it came to be, if you will, in the big spectrum of the police, of the public safety training center. But I will say that way before the announcement and before a city council meeting, there was obviously actions, discussions, and conversations in the works. And quite frankly, based on the evidence we have, for example, they were actually, there's evidence of threats, and damage done in furtherance of this conspiracy before the announcement was ever made. So obviously from that you can deduce that our evidence will show that whenever the government made it official is not really the question. It is when they started acting and when they developed their intent. And that is what we've alleged, started in May of 2020, and we believe we'll be able to prove it at trial.
Okay. Mr. Hudson?
What we've just heard is a proffer, Your Honor, not evidence. I'm going to direct the court to State v. Gamblin, 251 Georgia Ave 283. That's a 2001 case where the court held that absent some showing by the state that its evidence does not permit it to identify the exact dates of the crimes, we must conclude that the indictment counts in question are imperfect and thus subject to special demur. In other words, The burden, since the date issue has been raised, is shifted to the state to provide evidence of whether or not it can narrow the date range, not a proper evidence in the form of testimony. I will note that the state also said that many of the cases cited are in the realm of child molestation, and that is accurate, but not all of them. I'll direct the court to Cole v. State, which is 334 Georgia App 752. That was a Medicaid fraud case. And just going through a few different cases, including cases that involve child molestation, that stand for the proposition that without the state showing through evidence that it could not further narrow the date range, it is subject to a demur. State v. Meeks 309 Georgia Act 855, where the trial court granted the demur and the Court of Appeals affirmed because the state failed to demonstrate an inability to narrow the range of dates. You can go to Mosby v. State 319 Georgia App 642, a 2013 case. The trial court denied the demur and the Court of Appeals reversed and granted the demur because the state relied only on its argument that the date range exception applies. It did not provide evidence in support of that, which is similar to what we're at this point looking at here. That case quoted Blackman. Let's see if I have a citation for Blackman.
You gonna give me a minute to read all these cases, Mr. Henson?
If you would like to, I will sit down right now.
Because I think you just rattled off. Three plus the one I'm reading right now.
I'll take a seat. Let me know when this.
Now, that being said, I did have a fun time reading this weekend, and I did not see those cases in here. Otherwise, I would have looked at it. Fair?
Fair. I didn't anticipate a quibble over whether or not the state would need to present evidence that it couldn't narrow the date range. I thought that was pretty settled and established, but fair that I did not provide citation.
That was, okay. That was a judge I didn't think you'd have to think about. It's so obvious anybody would know.
I mean, I haven't heard counter citations, Your Honor.
Fair? And this is from the gambling case. Instead, we, like the trial court, are bound by the record before us. In absent showing by the state that its evidence was not permitted to identify the exact days of the crimes, we must conclude that the indictment counts for questions that are imperfect unless subject to a special demur. Is there a difference between, hey, we gave you a 2-year range, or they gave you specific dates in the indictment? It's from this date to this date. They didn't say a span of this year. The indictment is the indictment. May 25th, 2020, and August 25th, 2023.
That's a date.
So they're alleging a specific date of May 25th. With Medicaid, the 251 or the 334?
Medicaid is Colby State, 334, Georgia Act 752.
I'm looking at the Cole case. Indicted for offenses of Medicaid fraud over a date range beginning November 1st, 2010 through December 27th, 2013. True test of the sufficiency of an indictment to withstand a special demur is not whether it could have been made more definite and certain, but whether it contains the elements of the offense intended to be charged and sufficiently applies the defendant of what he or she must be prepared to meet in case any other proceedings are taken against him or her for a similar offense, whether the record shows with accuracy to what extent she may believe a former criminal conviction. It is useful to remember that the purpose of the indictment is to allow the defendant to prepare his or her defense intelligently and to protect him or her from double jeopardy. Trial court erred in overruling the special demur. Mr. Heslop, I get the date range, I get what you're saying here. I have Which of the multitude of microphones is below my court porch? Okay. What are you doing, Mr. Forte? Is that a problem?
A little bit.
I would note that of the multitude of overt acts in count one, all have specific dates on them. Does that not satisfy your specific dates within the date range?
Your Honor, I would note that an indictment is not evidence, and the burden is for the state to provide evidence that they could not narrow the date range.
Well, their date range runs from the date of the first of the overt acts. I mean, they listed a date range that is on the edges of the overt acts. Is that not specific dates?
Your Honor, I think we're parsing, but what I'm going to point out is the cases that I've referenced, starting with Gamblin, has specific dates. It has July 1st, 1998 through July 31st, 2000.
Yeah, that's a date range.
Right.
And we agree on that. And you're saying, count one says March 25th or 21st, 2020 through August. Right, and then within the same count, it lists specific dates that make up that date range. That's where they get the date range from.
It does make allegations, yes, Your Honor. What
So
I'm
if
asking,
they had listed the overt acts as individual counts, just for sake of argument, and each of those overt acts had a specific date, we wouldn't have a special demur problem. But if we collectively put all those dates together, and make a date range out of it, then we have a special demur problem?
we have a date of May 25th, 2020, which is a year and a half before the land swap.
Mhm.
This is an allegation.
Mhm.
The state is saying that it ties in with their one-count RICO count. If they can present evidence to that effect, we may not have a demur issue. I'm merely asking for them to provide and for me to be allowed to examine whoever they bring to testify to give their date range basis. In other words,
Here's where I think you're not communicating is, again, you focused on the land swap deal. What the state has said is this indictment incorporates more. This is not a land swap deal indictment. This is a RICO that is inclusive of that. It includes that issue. But that's not the entirety of the conspiracy.
and when we talk about getting into other demurrer issues and the sloppiness of the situation, we have amorphous titles called Defend the Forest, but also that this.
I've read, you're getting ahead, but yes, I hear you.
Okay, so.
Night of Rage, etc. I got you.
So if it's just, people don't like what somebody's doing and they're protesting and we're deciding that's criminal, well, that's a whole different conversation that we're going to be having.
Okay, well, your argument has been heard on the date range. Now, that being said, the first date alleged in the overt acts portion of count one is July 5th, 2020 versus March
25th.
March 25th. There is no March 25th
Over that.
overt act. Nate, what do you guys say about that? Anybody?
Judge, good morning. I'd like to note a couple of things up front. I know that counsel has indicated that he wishes to see evidence. I would point the court, as this court has already indicated and as counsel indicated, the counsel proffered. We are permitted to do that under Georgia law. Under State versus Battle, it's at 812 SE 2D1. Proffer is sufficient where a defendant does not timely object. Counsel does not timely object during counsel's argument, and therefore the proffer is sufficient.
I'm going to object, Your Honor. I don't know how I would be objecting during my argument. If he meant that I did not object during the state's argument, I want clarification.
He objected as soon as the state sat down. He went, "Hey, Your Honor, that's not evidence." That was pretty contemporaneous.
The court may find contemporaneous. I have a witness outside who's ready to go on this issue, but that said, what you have to do is during the evidence is you have to object and say, this is not evidence, we don't accept the proffer. You object during that, and then you don't wait till the end of the argument.
And I'm going to object again, and I'm going to note that even during the proffer, I didn't hear anything
Mr. Hensel? Sustained. No, Mr. Fowler, he objected, the court's gonna find he objected in a timely fashion.
I'm just going based upon what the Court of Appeals has told us on that. But going to the dates issue, this court is correct. The indictment outlines each and every individual date in the overt acts. And if you look at the cold case that counsel cited and the court was reading while on the bench, that's exactly what the cold case was getting at, which is that the problem with the indictment in the cold case was that it did not list the individual dates that the state alleged, I believe, 38 different acts. If I'm not mistaken, 38. They didn't list the individual dates, and that was problematic. Here, this indictment does. This indictment lists 225 different individual dates. On its face, it is perfectly fine. As Ms. Dixon indicated, and there's a statement from a co-defendant that indicates in this case when the conspiracy started. And that is where it starts, is that there is, if you will, a promotional video, for lack of a better way of calling it, where a co-defendant talks
Your
about when
Honor,
it
do I
started.
have to continue to object to proffering? Because we're now getting more proffering. There's a co-defendant statement. That's a proffer.
He's now contemporaneously objecting to your proffer.
It's a little late to Ms. Dixon's though, and I'm just repeating what Ms. Dixon said. And so that's all we have to do according to the cold case. Now, going to the court's question a moment ago, I want to address the court's question. You brought up a certain date, I believe it was May or March, and if I could just ask the court to repeat the question, if I could.
The dates alleged in count one, the date range is May 25th, 2020 is the first date. The date of the first overt act listed in part two of count one is on or about July 5th, 2020.
Yes.
And there are no dates prior to that. It looks like you go through all these, they are in date order all the way through overt act to something.
Yes, and that was the planning for the attack in July. That's what that was, but it alleges dates. It alleges specific dates in accordance with what the cold case requires. And so the defendant's demur should be denied.
Okay.
Thank you.
If y'all are waiting on rulings from the bench, you're not gonna get it. So,
Your Honor, I have nothing further on that issue. I will note that there are other issues raised in my demur that parallel issues by other counsel and I believe are better argued by other counsel.
okay, so who you going to the bullpen for?
I ask for the court to hear from Mr. Don Sandler.
Your Honor, before we go into that, may I address one question of clarification as we get to trial, based on the state's argument? It's my
If
understanding-
we get to trial.
If we get to trial. It sounds like what the court is hearing from the state is that they will prove that my client was in a conspiracy starting May 25th, 2020.
Hold on. Mr. Samuel, you knew you were going to be speaking, and you sat all the way down, and y'all let you sit down there with me first.
Check.
Go ahead.
just want to clarify what the being said from the state. It sounds like they're going to prove at trial this element that they're stating is that my client, each of our clients, is going to be in this conspiracy starting May 25th, 2020. I just
Well,
want
what
to
it sounds like is they're saying the conspiracy started in May of 2020, and at some point or another, these 61 folks came and went through this conspiracy. Not everybody joins a conspiracy at the same time.
I guess the
Some
language.
people join later, some people leave later, but that's the way I understand conspiracy.
And the language, as count 1 is written, is that they charge Spencer Liberto with the offense of racketeering, that said accused individually and as a person concerned in the commission of a crime, and together with unindicted co-conspirators in the state of Georgia and county of Fulton, on or between May 25th, 2020 and August 25th, 2023. And then they go on with the rest of the indictment of what he did. But the language of that says that's what Spencer Liberto did. Now, I'm not concerned necessarily with what the rest of these individuals did. I'm concerned with what Spencer did.
Mr. Kaczynski, Mr. Kaczynski, may you interrupt? I'm going to stop your interruption.
Okay.
Housekeeping question.
Go ahead.
The court's made clear that for pleadings, we have to individualize our demurs, our motions, we can't just adopt. This is the first time in the case, I think, where we have an objection, sort of procedurally, that a defendant has lodged. Do you want the other three who are here adopting that contemporaneously?
So I have to have all 4 of you say I want in on that one.
And my recommendation is that should be
Yes.
practice.
Yes. Unless otherwise stated, the 3 others will be joining in the objection. Unless you say, hey, Judge, I'm not in on that.
So it's an opt-out?
It's an opt-out.
Okay.
Yes.
Understood, thank you.
All right. Come on up, Mr. Chairman.
And just like we discussed, Your Honor, if we could, before Mr. Samuel begins, because Mr. Samuel does not represent any one of these defendants, we could just put it on the record that the defendants have no objection to Mr. Samuel arguing this for the purposes of later appellate.
Fair enough. I think Mr. Hetzel actually, not only does he not object, he actually invited Mr. Samuel to testify on his client's behalf. So, any objection, Mr. Hetzel?
Not for me, Your Honor.
Okay. Any objection from any of the other counsel?
I'm not opting out, Judge.
There you go.
No objection.
There you go.
Judges, another housekeeping matter just before we get started with Mr. Samuel.
I did not think my house was that dirty.
Mine is, I mean, after preparing for this motion, we won't talk about my house. So Judge, one request that the state would have is, when we talked about our scheduling conference, my understanding it was that we would handle, that each of them would argue, so Mr. Carroll, the attorneys for Carroll, Papali, and Marsicano, and Liberto, whoever, would argue their motions to count, demurs to count 1. And my request is, if we could go ahead and let everybody argue what they're gonna argue on that issue where they filed it, and then I would respond all at one time, instead of, just my request, instead of responding to each, because it's gonna be redundant, if that makes sense, to me, for me. Just a request.
Oh, it's going to be ugly.
I agree.
So, Mr. Samuel,
You want me to respond to that, or just make my?
just,
All right, Your Honor.
my response is, please proceed, Mr. Samuel.
All right. Your Honor, I represent Marlon Cox, Adele McLean, and Savannah Patterson, the members of the Atlanta Solidarity Fund, who were indicted being co-conspirators in this case. There are many issues raised in our demur. I'm sure you read the motion, the original motion, and the one that I filed again in accordance with your request on May 30th of this year. There are scores of issues. Maybe I could group them together in certain ways. Many of them deal with my clients and not necessarily with one of the first 4 in the first group. So it's a little confusing, but I am going to address all the issues in my demur. I don't think it makes sense, as you did with the prior argument, to take one issue at a time and have a response, but if that's what the court prefers, I'll break it down into different issues and you can
No,
get a
no,
response?
just Mr. Hessel sat down after the date range and he wanted to argue the date range first. I'm here for you all.
Okay. Well, I will, if you want a response from the prosecution at any point during my argument, then that's fine. Otherwise, I'm going to proceed from one argument to the next. Some of my arguments or blend into both general demur and special demur, the specific overt acts, specific aspects of the indictment that we consider to be right for special demur. But I'm going to discuss all the demur issues in this presentation. I would point out that the prosecution, since we originally filed our demurs close to 2 years ago, has never filed a response to our demurs. They haven't filed a response when we initially filed the demurs. They didn't file a response in anticipation of the oral argument before Judge Adams. They didn't brief the issue after the oral argument with Judge Adams. They haven't filed a response in anticipation of this argument today. So the only thing I know about the prosecution's response is the oral argument they made when we argued this before Judge Adams. I don't know if their response is the same today, so I'm a little bit at a loss to anticipate what their arguments are. I can't preempt what their responses are, but I will reserve time to reply what I may be hearing for the first time when they finally reveal what their explanation is for some of the defects in the indictment. And of course, I'll respond to any questions you have. We have broken down the demur issues into several categories, as I said. One deals with the problem. I'm only in the RICO count, by the way. We were originally indicted on several money laundering counts.
Nalprost.
They were nalprost because we filed the demur because they were so defective that I don't think even the prosecution intended that we go forward with those counts. They've been nalprost, they weren't re-indicted, so we're just dealing with the RICO conspiracy here. My clients, as you know from reading the indictments, out of the 225 overt acts are listed, and 80, 90 of them, maybe even more than that. But they do fit into general categories. There's a category I refer to as the seems no blog category of overt acts. There's these allegations, and I'm going to talk about this in great specificity, but I'm just kind of giving you the table of contents at this point. There's this allegation that our three clients, in addition to unknown co-conspirators, all authored calls to action, so to speak. We have seen no evidence of that in the discovery. Now, I'm not going to sit here and argue the insufficiency of the evidence, but it would have been nice had the indictment alleged some fact, any fact, that sufficiently alleged that the three members of the Solidarity Fund somehow had something to do with authoring documents that were, again, I'm going to refer to them as calls to action or suggestions that criminal conduct should occur. There's nothing in the discovery to verify that. And it also alleges in those counts that there were unindicted co-conspirators who participated. I don't know how many people in each one of those overt acts, it seems no blogs, overt acts, I don't know how many people are alleged to have supposedly authored these documents or somehow responsible for what showed up in a magazine or in a scene.
See no blogs?
Your Honor, if you take a look at the indictment, just the very first series of overt acts, look at just overt act 6, for example. That's the first one. 5, 6, 7, 8, 9.
Got it. The URL. Gotcha.
Yeah. And just so you know, and I'm not sure it's necessarily relevant to where we've even sat down with Mr. Fowler a year and a half ago and said, where is the evidence that either Mr. Counts or Ms. McClain or Ms. Patterson authored these, submitted them? What does it mean to say that they're co-conspirators along with unindicted, unknown co-conspirators who authored, these blog posts? And we were given essentially nothing. We were shown one document where the two names appeared on the same document. Atlanta Solidarity Fund and the Seams blog appeared on in one document together. There's no other evidence we've been shown. Now, again, I'm not sitting here arguing that they gotta prove their case in the indictment, but they have to allege the facts, which put us on sufficient notice so we can defend the case. That's the essence of a special demur. Allege sufficient facts so that the defense can prepare for trial. And they've alleged in the, whatever you want to call them, schemes de blague, overt acts, dozens of them. We're having to deal with trying to figure out who are unindicted, unknown co-conspirators. I assume they are not able to name them either, but at least by category. Where are these people located? What role did they play? What role did the 3 defendants who were listed in these overt acts? Over and over and over again. 3 people plus all the unindicted co-conspirators, all supposedly committed every one of these 30, 40 overt acts, all dealing with the schemes de blague allegations. I'm going to talk about those allegations more when I discuss some of the First Amendment problems here. So there are also numerous overt acts where they say there are known co-conspirators, but don't identify them. They've given us no information, zero information, about who the known unindicted co-conspirators are. Take a look at the overt acts beginning in '63 through somewhere in the mid-'70s. Maybe not quite a dozen, but almost a dozen overt acts where they say the defendants, again, always putting them as a group. They rarely, sometimes, but rarely even try to distinguish between Mr. Kaufman, Ms. McLean, and Ms. Patterson. But they say they engaged in various criminal acts with known unindicted co-conspirators, but never provide us information about who they are. That's a special demur issue. There are, out of the 224, 225 overt acts, it is impossible to figure out what are the actual predicate racketeering acts that are the object of the conspiracy versus overt acts which are perfectly innocent conduct. There's a clear distinction in the law between what is a racketeering act, a predicate act, has to be one of the codified crimes that satisfies the requirement in the RICO statute for to be a racketeering act, and an overt act, which can be perfectly innocent conduct in any conspiracy. If you and I decide we're going to go rob a bank, the object of the conspiracy is bank robbery. It's easy to identify, bank robbery. Give the elements of defense, FDIC insured bank, and et cetera, et cetera. An overt act might be that you and I had a phone call. That's not a crime that we had a phone call, or we drove to a store and purchased a gun legally. That would be an overt act, as opposed to the racketeering act, which is the actual bank robbery itself. The overt acts in this case don't differentiate between the two. And not a single overt act, not one, in this entire indictment, 224 overt acts, not one goes through the elements of any crime. So they really all are just overt acts, and there's never an identification of a predicate act in which they have alleged the essential elements of defense. And we've cited to you Heath case and Sanders case. We put it in various places in our brief in which the court have said whenever there is a compound crime, and RICO is the essence of a compound crime, you have to set forth the elements of the underlying predicate offense. Not one in this indictment. Substantive crimes that I'm not involved in obviously go through the elements of defense. But not one time in this indictment do they say that Mr. Couts, Ms. McClain, Ms. Patterson, committed the following, or conspired to, or did in fact commit any of the following crimes, or conspired to commit any of the following crimes, and then list the elements. So we can know that we're talking about, there's the conspiracy the RICO allegation supposedly focuses on. They conspired to commit, the use of a Molotov cocktail to assault a police officer and go through the elements of the crime. Not once in this indictment does the indictment satisfy the Heath and Sanders rule that you have to set forth the underlying predicate offense with specificity, both factually, Sanders in particular does that, both factually and the elements of the offense. So we have problems identifying unindicted co-conspirators. We have problems with somehow throwing in co-conspirators. We have no idea whether they're going to claim that we were simply a party to a crime with some unindicted co-conspirator who committed this offense. And you're just kind of responsible on kind of a Pinkerton theory. You know, Pinkerton, where every conspirator is responsible for what everybody else does. So we challenge the indictment for those reasons. The failure to differentiate racketeering acts from overt acts in the indictment.
Because merely reimbursing someone for money is an overt act.
There's no doubt about it, it's an overt act.
Sure.
But you gotta spell out in the indictment, and I'm gonna come to this shortly, how did the overt act further the goals of the conspiracy? It's not just a question of proof at trial. When I gave you the example of a bank robbery, when you and I went to the store to buy a gun, yes, that's an overt act. But did we go to the store to buy the gun in order to go rob the bank? That's what's gotta be in the indictment. You gotta show how the overt act materially advances the cause or somehow is related. All this says is we bought food.
Is the word you're going for nexus?
Yeah, of course, well, it's the essence of RICO, is the nexus between the racketeering acts and the enterprise. The nexus between the racketeering acts and the overall scheme here, which is completely missing. I'm not even there yet to talk about the relationship. The enterprise itself is shockingly ill-defined, if you will. I don't mean to get so overwrought here, but you know that the enterprise is defined in various places in the indictment, most notably around pages 23, 24, 25. This is all in the indictment. This is not, you know, the introductory stuff. This is count one. They allege the enterprise beginning on page 24, actually in 25. At various parts, the enterprise is defined as a movement. Can you imagine that? That an enterprise is a movement? You know, the civil rights movement would be characterized as an enterprise according to the Attorney General's office in this case. At other times they describe it as a coalition. I don't even know what that means. I know the word coalition means, but a coalition they describe environmentalists, plus anarchists, plus eco-terrorists. I know what Mr. Fowler's going to say, or Ms. Dixon's going to say, or, you know, representatives from the AG's office, they're going to say, well, an enterprise can be just association in fact, and that's true. It could be a police department, it could be a governor's office, it could be anything. But somehow it has to have some defined structure. That's the United States Supreme Court case, which is the leader of the Boyle case. Remember that the enterprise can't just be the acts themselves. You can't define the enterprise, which is the essence of RICO, racketeer, influence, corrupt organization. That's the O in RICO. There has to be an enterprise which is separate and apart from the acts that are committed. If you're just going to allege a bunch of crimes, you don't have RICO. And you have all kinds of venue problems at that point. You can't prove that the acts occurred in Fulton County or DeKalb County. You even have statute of limitations problems. If they're all part of the enterprise, that's why you use RICO, is to try to get them all into one case. But the enterprise here is so ill-defined and so hard to grapple with. I'll point out that my predecessor up here at the podium, his argument's fine. I think his argument's wonderful. I think another way to characterize his argument is, if the enterprise throughout was to prevent Cop City, or the training center, was to prevent building on the farm, how could they allege predicate acts that occurred before any of them existed? They couldn't have been predicate acts relating to the enterprise. That, to me, is the problem with the date ranges they've used, with the earlier overt acts. If the enterprise was designed, the whole purpose of the enterprise, the existence of the enterprise, was to stop the training center and to protect the forest. Those were the essence of what put these people into one group. And yet it occurred before any of those things happened. Then the enterprise has lost all structure. Dixon says, well, we'll just prove it at trial. But they're not going to prove what they alleged, because what they alleged as the enterprise had nothing to do with Rayshard Brooks. That's the May and shooting in Minneapolis, George Floyd.
Rayshard Brooks was here.
Rayshard Brooks was here, George Floyd was in Minnesota. But that's the date range they're picking up. They're saying those events is when the enterprise began. And yet they go, throughout the rest of the cases, the enterprise is the forest, either the training center or the environmental problems. I just add that because of what the argument was before. To me, the date range is inconsistent with the enterprise that they've defined. That's the problem. And I raised it in our brief as a problem with the definition of an enterprise, that they are incapable of defining the enterprise with any meaningful structure or membership. Lord knows how many unindicted co-conspirators they're going to end up talking about at trial without ever identifying them, or how many known co-conspirators they're going to identify at trial, maybe for the first time, since they haven't identified them yet. I mean, there may be thousands of people who they're going to say are members of this enterprise. They may say, because they suggested, any anarchist in the country is a member of this enterprise. California, New York, Boston, they mention all of that. It's all in their indictment, in their introductory sections about we're going to, commit crimes in New York and Boston and California, and we're going to go after this enterprise is larger than the Vietnam protests, as far as I can tell. As far as I'm concerned, if I was protesting the Vietnam War back in the 60s, I'd be part of the enterprise, because some of the people committed crimes during those protests. What are you going to do with the NAACP? There were crimes committed. There was trespassing that was committed. There was civil disobedience that was committed. And there were even some violent acts committed. And some of those people belonged to the NAACP. You're going to say that's an enterprise? And it was all part of one RICO case because some members of the enterprise or some members of the group engaged in criminal conduct. The United States Supreme Court says you can't do that. The NAACP versus Claiborne Hardware, which we've cited in our brief. You can join a group. You can be a member of an organization or a movement or a coalition and not be guilty of a crime, even if other members of the movement or coalition do commit crimes. And that's what they've done here. They've taken all these people and thrown them in an enterprise and said, here's your RICO. They're all racketeers. So that's, the argument that we make in our brief, in our demur, challenging the definition of an enterprise. It is too amorphous. It is indistinguishable from the acts, from the criminal acts that they claim that the enterprise members committed, and it sweeps in so many innocent people who were just members of a movement or members of a coalition, and then includes, as I said, how many hundreds or thousands of unindicted co-conspirators who were, quote, anarchists or defund the police individuals, or people who protested George Floyd, the BLM, or protested the Rayshard Brooks shooting. They're all, now we know, they're all part of it because they alleged it, that's when the enterprise began. The hundreds or thousands of people who protested, police brutality in this country. So that's our enterprise allegations. I don't even know where to begin with the 25 pages that count one starts with. I do a lot of practice in federal court. There's a lot of speaking indictments there. They allege to have introductory language, which is, in my view, offensive, but clearly tied to the crime, right? I mean, there'll be introductory language, you know, in healthcare fraud cases that explain a little bit about the history of Medicare and how it works, and it doesn't look like a typical indictment, but it's clearly focused on the actual crime that is set forth in the ensuing counts of the indictment, talking about what we call speaking indictments in federal court. And I don't know if the Attorney General's office in this case tried to learn from that. But I seriously, Judge, ask you to really carefully read pages 25 through 49 of this indictment.
The court has read the entire indictment.
Yeah, well, you want to read it again because it's shocking. It is absolutely shocking that any prosecutor in this country would think that belongs in an indictment. I am absolutely appalled that the Attorney General's office in this state believes that it's appropriate to present to a grand jury and to present to the jury in this case, to you, to the public, to the press, 25 pages that discuss, can I quote just a few excerpts?
It's your record, Mr. Samuel,
It's their indictment.
that I don't have to read to a jury.
They read it to the grand jury. The jury has to be told what the indictment is that the grand jury returned. They can't return an indictment or a verdict for something the grand jury didn't indict for. And the grand jury, I've never been in a trial where the jury doesn't get the indictment to deliberate in state court. But this indictment begins with talking about anarchist ideals. We're anarchists, you know. I mean, they clearly blame my three clients as being anarchists. Anarchist ideals date back centuries. Well, that's a hell of a thing we're going to have to defend against. Is that going to be something that the jury is going to have to find beyond a reasonable doubt? Are they going to be told about the history of anarchism? Are they going to present evidence of that at trial? Violence is part of the anarchism in some anarchist beliefs. Anarchists often point to law enforcement as one of the chief violent actors in society. Violent anarchists often engage in violent activity towards law enforcement. This is totally ill-defined. I'm not talking about our case. I'm not talking about our case at all at this point in the indictment. But you want to know some other examples? Well, they provide them in the indictment. Examples include 2020 movement in Portland, Oregon, Seattle, Washington, the latter known as the Capitol Hill Autonomous Zone, that's in Washington. And of course, later there was the Autonomous Zone in Atlanta. This is all in the indictment. This is all what the grand jury was asked to sign their names to. And then it goes on to start quoting anonymous people, black-clad, masked people who gave speeches about defending the Atlanta forest. They put that in the indictment, as if that's relevant to anything that's going to happen at this trial. Are they going to just abandon the confrontation clause? Are they going to put in evidence of what masked people said outside the courtroom, never going to be cross-examined about what this movement should be doing? We need to kill more policemen. A known Defend the Atlanta Forest was recorded complaining that there were not enough violent members in protests against the training center. That's in the first 25 pages of this indictment. Then we get compared to Mexican Zapatistas, Syrian revolutionaries. That's what we're being compared to. Kurdish revolutionaries in Afghanistan. What is this doing in an indictment in this country, in this county? We raised all these arguments to Judge Adams, with all due respect, not a word in the original order in this case said there was anything improper about that. As if we all need a pseudo-history lesson from the Attorney General about, you know, the background of my clients, their historical predecessors. This pseudo-history that has no business in an indictment. And I don't know what you're going to do with it. You're just going to throw it out and say, we'll let the prosecution prosecute whatever they want in this case. We're going to throw out the first 25 pages, because that's clearly inappropriate. It's full of hearsay and confrontation clause and, as I put in my brief, events that happened centuries ago. I would really like, if I can pose a request to you, that you ask them, what in the heck was that doing in this indictment? What were those 25 pages designed to do? Who was the audience for those 25 pages? It is, I think I've already said it was offensive, that you may be able to gather from my tone of voice. It is inexplicable to me why this indictment wasn't dismissed within weeks of it being returned with that kind of BS in it. We have devoted a substantial part of our demur to the First Amendment issues in this case. And they are, the indictment is just saturated with assaults on the First Amendment. It is throughout the indictment, from beginning to end, there are allegations of conduct which is clearly protected by the First Amendment, as if it's a crime. From the definition of the enterprise, you're an anarchist. Clearly First Amendment protected. That's like saying the enterprise in this case is full of people who belong to the NAACP. Can you imagine something like that in an indictment? They say that the enterprise in this case was comprised of people who are anarchists, who are involved in protecting the environment, people who are engaged in direct action. I did that. Did you do that? I do it on weekends now when I go out and do the No Kings marches. Is that an enterprise? Promoting anarchist ideas? Next thing you know, they're going to say it's a crime to promote democratic ideals or Republican ideals. As if that makes you part of an enterprise and violates everybody's First Amendment rights.
I'm a little more constrained than you are by the Judicial Code of Ethics, Mr. Samuel. I'm not out on weekends.
Say that again?
I said I'm a little more constrained than you are by the Judicial Canons of Ethics. I don't go out on weekends.
Yeah. Well, I know I've seen members of my colleagues in the defense out there, and they wonder, I guess we're next, right? We're out there protesting, probably trespassing, not within the bounds of where the parade is supposed to be. The overt acts that so, even the scenes block, even the offensive scenes block, it's going to offend the juror if you read some of these. But the United States Supreme Court has said, unless it's an immediate incitement of riot, Randon versus Ohio and the United States versus Scales and all the cases we read about in law school, unless you are inciting a riot, you are not guilty, even if you're calling to action, even if you're encouraging what would be described as criminal activity. It's protected unless it is an immediate incitement to riot. We've cited those cases to you. I keep telling you that because I don't want you to blame me for bringing up cases here that weren't in the brief.
I wasn't blaming Mr. Hetzel. I was just commenting.
Well, thank you, Your Honor.
We're on the same side here.
Couldn't tell by that.
Then we have the problem in
indictment, not just the First Amendment, which is part of the Scenes Blog problem, but the lack of any connection between, and we mentioned this earlier, the lack of any connection between these alleged overt acts and any criminal conduct in the indictment. Right? Yeah. Now, Ms. Dixon may get up and say, well, we'll just have to prove it at trial. Well, these are demurs. And the basis of these demurs is you haven't given us the information to defend, number one. And number two, you haven't constrained what the jury can do. Because if you can say, well, you woke up in the morning, and that was an overt act, well, then they can prove anything at trial. They've got to prove what's alleged here, and then what's alleged here were overt acts that furthered the ends of the conspiracy. Buying food. Dozens of overt acts. You reimburse someone who bought food with no allegation anywhere in this indictment what that had to do with anything. Where was the food eaten? Where was the food brought? Who, there's nothing. And don't let them stand up here, the AG's office, and say, well, we'll show you a trial. They're supposed to show it in the indictment. That's what an indictment does. It's the blueprint for trial. It tells you where the structures are, where the steel beams go. Well, this doesn't tell us anything. You paid for food. You paid for deep May, which was, maybe you remember seeing some of that in the indictment. Like, what the heck is deep May? It was a computer training class for teenagers and young adults. There were professors who came from the university, came down here and taught people how to do troubleshooting on a computer. What is that doing in this indictment? And don't let them tell you, because it's not in the indictment. Don't let them stand up here and tell you, oh, I'll tell you what's bad about that. It's X, Y, Z. It's in the indictment, if it's going to be X, Y, Z. That's why we have indictments. That's why we have all the rules of discovery. But even that's not enough. If it's not in the indictment, then how's the jury going to know whether they're convicting them of something with which they are charged? The relationship between the racketeering acts and the enterprise is exactly what Kimbrough's all about. I think you mentioned Kimbrough when I stood up here. And that's kind of the essence of the demur problem. But that's just one problem. That just deals with the relationship between the crimes and the enterprise. And Kimbrough is clearly the lead case on that point. The First Amendment, there's just no shortage of cases, including, again, in our brief, the recent Ninth Circuit case that even found the federal statute defining riot act unconstitutional because it didn't clearly and directly focus the incitement and the crime. It wasn't a close enough link. And all these scenes blog allegations in the indictment are defective for that reason. I mentioned before this whole problem of all these overt acts that just have who knows how many different members, unidentified, some known, some unknown, and I have no idea. I've been working on this case for 2 years. I've been representing the clients for time before that. You know that from the filter team problems. To say that Cash, McClain, and a bunch of unindicted co-conspirators all did X. How am I supposed to prepare for that? All three of them did it? One of them did it? The unindicted people did it? But you're all being held responsible. You're all being held responsible because you're parties to the crime, without any definition of who did what. Your Honor, the indictment in this case is, with all due respect to my colleagues, it is a disgrace. Amendment. It's an assault on the right of people to protest. It is grouping all these people together and claiming that they're all a bunch of anarchists and criminals, that they should go to prison for the racketeering act of 20 years. Some of these people, were down here for one day. They went out, they protested, and they're now being labeled racketeers. My clients never are alleged to have gone out to the forest. Not once. They are firm believers in the First Amendment. They exercise their rights under the First Amendment. They have a right to do that. You should be protecting it. The AG's office should be protecting it. And if necessary, we will be asking the jury to protect it. But you should put a stop to this, with all due respect, Your Honor. You should say, you want to indict someone for throwing a Molotov cocktail, indict him for throwing a Molotov cocktail, and don't indict 61 people. You want to indict someone for threatening a construction company, indict him for that, if you got venue. And I ask you to grant the general demur, grant the special demur, and tell the Attorney General this is not how we conduct criminal business in this state.
State?
I think I'm gonna start, do my best to answer what was alleged and argued, and yet still stick somewhat to organized presentation of the argument to you. To do that, I'm gonna start with just a key point, excuse me. First, one of the things that is important is there was an argument about the introduction as if it was separate from count one. I would just like to point out for the record that the introduction to this, which talks about, defines, and articulates facts pertaining to the enterprise, is actually contained in count one. It is part of count one. So that introduction in the body of the indictment is part of count one. That's just a housekeeping thing. However, there's a couple of.
I think that was part of his complaint.
Okay.
I think he agrees with you,
Agreed.
Mr. Samuel.
Yeah, exactly, that's the problem. If it wasn't part of count one, who would care?
Well, and Judge, so I'll get to that. And there's a separate motion, and I think Mr. Fowler will address, there is a motion specifically about the political rhetoric in the
There are
complaint.
many motions
Yes,
regarding the
agreed.
political rhetoric.
And Mr. Fowler will be predominantly addressing that. I'll hit on it a little bit. But there's a lot of issues to cover. I'm going to try to hit them all. And Your Honor, the indictment in this case charges the necessary elements of conspiracy to commit RICO. And I want to just, and I know this after in response, it seems kind of anticlimactic to get up and just talk to you about the elements, but that is what we're here to establish, is whether or not the state actually alleged sufficiently the elements of the offense. And I won't go through all of exactly what is said, because the court has read and studied the indictment. But count one does specifically set out that the individuals charged acted together, individually and as parties to a crime, or as persons concerned with commission of the crime, that is in there. They acted together with unindicted co-conspirators, together and with unindicted co-conspirators. It alleges the date range. It alleges that they did so while associated with an enterprise. They unlawfully conspired and endeavored. And it alleges the enterprise as well as the pattern of racketeering. And then, Judge, and I just need, there's a lot in this indictment, which the state is very well of. But part one defines the enterprise, and that's where they started a lot of complaints about the enterprise. And in part one, it gives the overarching intent of the enterprise. It gives how the racketeering activities are connected. It talks.
It's a bad political science paper. I never thought a political science degree would help me. It clearly is the first time since graduating other than from law school. There's problems with this.
And Judge, I will get back to the, or what might be surplusage or unnecessary in there. But the reality of it is that as far as whether we alleged, because one of the things they are saying is that
How
we.
is Aleppo?
I'm sorry?
How is Aleppo gonna go in front of a jury?
I'm sorry.
How is Aleppo gonna go in front of a jury in this case?
Okay, Mr. Fowler said he'll handle that.
Okay.
All right, Judge. So, to address everything, because we need to establish the record, there are two key things that are in paragraphs A and B. Two instrumental and key things. Paragraph A, the indictment alleges that each individual charged in this indictment knowingly joined the conspiracy in an attempt to prevent the training center from being built. It also alleges that the conspiracy contained a common purpose to commit 2 or more acts of racketeering. And then in count B, Judge, the indictment goes on as in describing the enterprise.
In paragraph B?
Yes, excuse me, paragraph B in the introduction, Judge. It goes on to articulate and allege that the defend the Atlanta Force, which is the defined enterprise, is a self-identified coalition and enterprise, and then it goes on. And what is key, though, because we do have to allege the nexus, is that paragraph B to the introductions affirmatively alleges that defend the Atlanta Forest, this enterprise, conducts direct action designed to prevent the construction of the Atlanta Public Safety Training Center and Shadowbox Studios and promote anarchist ideas. That the self-proclaimed direct action has included vandalizing private property, arson, destruction of government property, attacks on utility workers, attacks on law enforcement, attacks on private citizens, and gun violence. It also alleges that the purpose of these actions is to prevent the construction of the Atlanta Public Safety Training Center and a movie studio, all while promoting the virulent anarchist ideals. So in the intro paragraph to the indictment, it sets out what the enterprise is, who this group is. It gives a lot of other detail, which I'll get to, but it also establishes an allegation regarding a nexus between their activity and their end goal, or the motives and the end goal of the participants in the conspiracy, or the enterprise, excuse me. And so then in count 2, I'm just gonna, what do we have to allege? Count 2 says the defendant committed overt acts to affect the object of the conspiracy, which include acts of racketeering activity as described below. The indictment then sets out 225 overt acts, some of which are predicate acts, and I'm going to talk, unfortunately, extensively about which of those are and what the law is there. But those 225 overt acts contain allegations of a multitude of racketeering activity acts. And they include influencing witnesses, assault, aggravated assault with firearms, domestic terrorism, arson, and acts and threats involving arson and felony obstruction. And like I said, I'll address some of where that is in a moment. But as the court knows, and as the defendants have argued in a lot of their motions, the test for general demur is, can a defendant admit all of the facts in the count, in each and every count, the entirety of the indictment, and still remain innocent? And I'm going to come back to that because Mr. Samuel didn't really address it, and I believe others will. But that is what the test is, and the state asserts that Judge, and we can pull it out. They absolutely, general demur is not going to get them there, because if they admit each and every allegation in this indictment, they are definitely going to be guilty of multiple offenses, including RICO. Now, I'm going to go ahead, Judge. Let me see. whether the enterprise was sufficiently alleged. There's a multitude of arguments from different defendants about the structure. Mr. Samuel did mention it. And I'm going to read for the court. All right. Yes. Thompson v. State, 211, Georgia App, 887 at 890. It's a 1994 case, Judge. That is just one of the things it says, is that appellants contend that they did not have requisite knowledge of the criminal element of enterprise to sustain their RICO convictions. But none of the provisions of the RICO Act, however, requires that each and every defendant in an enterprise have full knowledge of all facts or all facets and elements of the enterprise, and that all members or actors, and in all of its members or actors. An enterprise is not a criminal act itself. It is a description of the entities involved in the RICO violations and may include activities involved in illicit as well as licit activities. It is the racketeering activity, the pattern of racketeering, the predicate acts, which is illegal, not the enterprise itself. Although the enterprise may be proved by the same evidence which proves a pattern of racketeering activity. And Judge, in addition, and we'll talk about the structure in a minute, but while some structure is required, this indictment more than does that. And in paragraph 3 of the indictment, as far as how we allege this enterprise, I mean, this indictment talks about how they recruit, how they're trained, what the connection to each other is, what their motive is, what their end goal is, what different, it alleges different,
Paragraph 3.
excuse me, I'm sorry, I'm just going, paragraph 3 of the introduction explains how the propaganda, recruiting, providing finance, it talks about.
Just give me a page number, because paragraph 3, count 1 has A, B, C. Part 1.
Oh,
You have part 1, then you have A, B, C, D, F, and you have part 2.
gotcha.
So
Let me, 2 seconds, Judge. I did say paragraph 3, and I apologize.
part 2 is the overt act.
I think, what page is that, Jim? I think it's page 28, Judge. And let me just generally characterize it, if I can. In the introduction, which the court has studied, the indictment sets out the propaganda, the recruiting. It sets out how finances are provided, who is provided, or what entities are providing, how they shift money and pay money and what they're paying it for. It sets out how the enterprise provides support, emotional, personal, preparation for arrest. It alleges that it provides premeditation, or the enterprise premeditates committing crimes, and that all of those things are part of this enterprise. On page 33, paragraph, anyway, it specifically talks about, in the introduction, how this enterprise is designed and does promote and agree to promote conduct
On page 27, a local
Yes.
anarchist supporting the Stop Cop City movement
Yes.
recently wrote. Any idea who that is? Any idea how these people are supposed to know who that is? Any idea? As noted by the anarchist above.
Judge, I think it's, from what I understand, it's in the discovery, right? Is it a part of Scenes blogs, or is it one of the? It's in the discovery.
The indictment.
Yes.
court considers whether an indictment is sufficient to withstand a special demur, it is useful to remember that a purpose of the indictment, not the discovery,
Yes.
is to allow a defendant to prepare her defense intelligently. So, looking at the indictment, their argument is you can't fix an indictment with 10 terabytes of discovery.
And I understand,
They should be able to look at this 109-page document and go,
Yes.
here's what we got coming at us.
Yes.
And unnamed quotes, that's problematic.
And as I.
It's in the discovery is not a good answer, is what I'm telling you.
So, and Judge, let me just go ahead and skip to this issue. So the indictment contains things, and I think in the last trial, in Isla King's trial, when we had it.
We have not had an Isla King trial.
Okay, in the previous.
We have not had a trial in this case.
Previously, when we prepared for trial in front of a different judge, we, with the defense, the state and the defense got together and they agreed that certain items would be redacted. And that, or certain statements, certain portions of it would be redacted. And that is, again, what the state's position is.
And that's because that defendant announced ready for trial by filing the speedy. These folks have not announced ready.
And the state's position, and again, Mr. Fowler is going to, do you want him to go ahead and do it instead of coming back around to it, because he is prepared to.
I'm here for the
articulate
duration, y'all do whatever.
do you wanna go ahead and address the rhetoric issue? Because I think there's a separate motion, but let's go ahead and address that.
Thank you, Judge, and I apologize for kind of the we call it whack-a-mole way of standing up and sitting down. I think that's how the game works, but the way that the motions were filed, so I'll go ahead and get right to it. And that is that one of the things.
I just want to keep up. What motion are we on now?
I believe it's number 17 on your list.
17?
Yes.
No.
Well,
No.
it's the same motion, and this is the issue that we had. It's the same motion that they just argued, but it overlaps with 17 is what I'm telling counsel. And this was our difficulty in getting prepared for this, is that there are separate motions that are filed by certain defendants that also contain the same argument in the first motion that Mr. Samuel just argued. So that's when I say 17, it's a separate motion that was filed by Mr. Carroll that is on the list, that is also included in the argument that Mr. Samuel makes. So when I tell him 17, that's one.
Yes, Mr. Schwartz?
No, Judge, we're happy to cooperate here. Let's see how it goes.
Look, there's no question that there's a ton of overlap. And I understand that's why the previous judge may have done things the way she did. That's the way she's used to working, and that's fine for her. And I made you guys parse it out separately. That doesn't stop the fact that there is overlap between y'all's motions. So, all the housekeeping in the world isn't gonna stop this from being a little bit sloppy and piecemeal. Go ahead.
Thank you, Judge. So let me start with this, which is that one of the things that was raised was the complaint that the Scenes blog did not adequately allege in the indictment that they are able to attack that. Now let me give the court a little bit of background, because the court kind of made a face when they started talking about the Scenes blog or scenes.blogs.com, whatever it is. And counsel is right, that the Scenes blog is outrageous, because what it does as part of this conspiracy is get online, post online, hey, we just burned this stuff to the ground, we're going to do it again, and if you don't stop the training center, stop building the training center, we're going to keep building your stuff down.
And correct me if I'm wrong, Mr. Samuel, I think his argument was there's nothing in the indictment tying his folks to it. We got the metadata from their whatever. We got something. It's just, these folks, along with people we don't know, or unindicted co-conspirators that are unknown, along with people we don't know. So,
Did publish.
basically, keyboard warriors.
Did publish. Yeah, not just keyboard warriors. I mean, keyboard warriors get up and argue a purpose. This went further than that. This went further than that. This went much further than This was intended to intimidate witnesses. And that's the allegation, because if you look at it, we give them the date, we give them the internet website, we give them the contents of the post, we give them the intent of the post, and we say who did it and that they published it. That is a lot of information. That is a lot of information to be part of an allegation. We didn't just say that they believed this. We didn't just say that they did this. We give them date. We give them date. We give them contents. We give them purpose and intent. We give them motive, and we allege who did it. That is plenty to do it. In fact, we actually allege, if you take a look at it, we allege the elements of witness intimidation in that overt act right there, which would be sufficient as an independent crime in and of itself. But this is merely an overt act, and overt acts don't require that there are crimes. So not only did we sufficiently allege it, but we more than sufficiently alleged it. And I know that it appears that Mr. Samuel had his caffeine this morning when he got up here, but the reality is that we did more than we needed to do when it comes to the scenes blog sort of stuff. They claim that it's First Amendment protected, and there are First Amendment protections, and we're starting to get into a little bit of a different argument over breadth, which I will address differently, which I'll address in a different argument, I think, unless I need to go ahead and do it now. But obviously, you can't just say anything that you want. You can't. There are limitations to the First Amendment when it comes to what you say and the things that you do. But I will address overbreadth later on. Coming back to this, you don't have to allege how it furthered the objective. That's their primary. You don't have, or how it furthered the nexus. You don't have to allege that. You simply have to allege that it's an overt act in furtherance of the conspiracy. That's all you have to allege. That is the only language that is required, and it is listed in a separate sentence after all 225 overt acts.
You got a cite for that?
But it's back. I will get it to the court.
Go get it. I want it now.
Um,
No, if it's at your table, I want it.
What is the principle that you're needing a cite for?
Yeah, you don't have to.
To allege something is an overt act in furtherance of the conspiracy. You don't need a nexus between them.
The overt act? Or
Yes.
Yep.
As for the political rhetoric, what the court called, I think, a bad political science paper, that bad political science paper we got from the defendants themselves in the documents that we located, in search warrants, in the forest and documents that we found. This is where we get it. And it's important to understand that this is how we get here in this case. And I know it reads unlike anything we've seen before. It's certainly something that I've never seen before. And let me give the court a different example of indictments that are fine when we do something like this. And I know we've talked about gang cases before. This happens in gang indictments too. How do gangs get where they are today, leading to the violence or the fraud that they do, kind of depending on the gang. And you can do that. You can make that part of it. And I'll cite to the court, I believe it's, and this is there's a Second Circuit case, United States versus Scarpa, when the defendants unsuccessfully moved to strike 16 paragraphs captioned Introduction to All Counts, which was devoted to an overview and history of the Genovese organized crime family, which was a racketeering prosecution, and how it began, and how it got where it got, and the beliefs of the organized crime family, and how all of those tied together. In addition to that, and even if the court doesn't think that that language should be in the indictment, what's interesting is that counsel filed a demur, but I point the court to a,
You give me a cite on that one?
I'm sorry,
It's
if I
a
did not
Second Circuit
apologize.
case.
Yes, it's 913 F second 993, page 1013. I would also give the courts United States versus Bellomo, Bellomo, 263 F sub second 561. And so you don't have to scroll forever. It's pages 584 through 585. I know that counsel filed a demur to the indictment, but demurs are not the proper vehicle for this. The proper vehicle and the remedy that counsel needs to ask for, and the proper remedy is if there is surplusage in the first part, this court does not think needs to go to the jury, in which case it would be surplusage. The state doesn't have to prove it, would be to ask for it to be redacted. And there's a case, it's just an opinion out of the Superior Court of Cobb County, so it's not persuasive on this court, but it's well written, I will say that.
It's not persuasive, really, Cobb County.
It's not binding on this court. How's that? Maybe that's a better terminology. I don't know which judge wrote that, but I hope they're not listening right now. And it is 215 Georgia Super Lexus 7038. And it's a finding in motion for new trial. The trial counsel was not ineffective for failure to file a non-timely demur. And they don't really talk about the timeliness of it. But it does say, in such a situations, a motion to strike the surplusage, which was never filed, rather than a dismissal of the entire count, is the appropriate remedy. And it cites to United States versus Goodman. That's 285 F. 2nd 378. It also says that even if an indictment is lengthy and needlessly verbose, it does not mandate that it need to be dismissed. Instead, the defendant's proper recourse is to file a motion to strike surplusage from the indictment. That's United States versus Watson, 2008, U.S. District, Lexus 59323. There are Georgia cases on that as well, where the cases have found that refusing to strike surplusage in an indictment is harmless. That's, I think it's Malov, M-A-L-L-O-V. I don't think it cut it off in Malloy. I think it's Malov, however you say it, versus the state. 293, Georgia 350. Supreme Court dealt with an indictment charging Medicare fraud, which included language beyond the statutory language. The court noted that surplusage does not vitiate an otherwise valid indictment. And that cites to State versus Barnett, 268, Georgia Appeals 900. I would note that in the Barnett case, the court ordered that the term family violence be redacted from the indictment in the introduction. It doesn't really get into how it wasn't, but somehow it made it to the jury. And the court later found that that wasn't an issue because it wasn't something that the state had to prove. And so it's an allegation that the jury read it and therefore convicted because they were somehow poisoned by that or tainted by that. The court dismissed that and said no, it has to do with the evidence that goes before the court. Finally, there's another case that stands for it. I'll go ahead and give it to the court. It's Eidson versus the state, E-I-D-S-O-N, 262, Georgia Appeals 664. That's a 2003 case. So I give the court all of that to let the court know that even if there is any part of that, it shouldn't be in there. The proper remedy is a redaction, like Ms. Dixon was getting at when we were preparing for the Isla King in front of Judge Adams. That the proper remedy is to redact it. Now, we never reached that for a number of reasons, but that's a totally separate issue we're not addressing today. That would be the proper way. I would suggest to the court that it's not. That these are things that these defendants had in documentation, things that they wrote, things that they said, all of that sort of stuff. And this history lesson, while I agree with you, it's an unusual history lesson, comes from these defendants themselves. It explains how we got here, and the motive for the reason that they do things. And we talk about that a little bit in the indictment. When we talk about the nexus while promoting anarchist ideas, and we talk about that as part of the nexus and part of the violence and the property damage, the gun violence, the arsons, the going after civilians who are just doing their jobs, all of that sort of stuff is part and parcel of this case. And for those reasons, we believe it should go out with the jury. If it doesn't, the proper remedy is merely redaction. And I believe that I will now turn it back over to my colleague.
Okay.
So that's the state's response regarding the alleged rhetoric in the introductory paragraph, Judge. The other things that the state has argued, or the defense has argued, particularly Mr. Samuels, is that the indictment is violative of the First Amendment, and in the speech and the assembly and the right to associate. And again, we'll have other motions, so I don't want to hammer the point. It was a passing reference or in multiple of these. But first and foremost, the reality of it is, read the indictment, because it is this argument that they're making that the state, through charging this, basically said if you protest you're a racketeer, is essentially ignoring the contents of the indictment. The indictment makes it very, very clear. And quite frankly, my co-counsel and I have talked about this, we unabashedly and absolutely unequivocally agree that who you associate with, what you believe, in the quiet of your own home particularly, what you may say to somebody, that you can believe completely different, you can believe unpopular, you can believe popular. None of that, all of that I should say, is protected, 1,000%. But what you can't do is, because of those beliefs or for any other reason or some other belief, you absolutely cannot agree and join in with a group of individuals who are associated in their conduct and in the way they conduct themselves, in their beliefs, whatever it may be. If they're associated in their, in fact, in the way they are conducting their affairs, you cannot agree and become a part of this enterprise, therefore, and agree that you're going to, or your co-conspirators, or somebody else in the enterprise is going to go out and commit certain crimes or acts or threats involving certain crimes. And we'll get to that in a minute. So the reality of it is, people can get up and wave their arms and yell and scream about the First Amendment and become insulted and indignant. But this indictment in no way is talking about this. The indictment is charging people not with their beliefs. Their beliefs are their motive. They're evidence of their motive. What they say is evidence of their intent and their motive. Absolutely. The state will say, yes, that's true. That's established law in this state and elsewhere. That speech can be used as evidence of intent and motive. But the reality of it is that while you can associate with who you want, you can protest. You can peaceably assemble, you can protest, you can do all of those things. What you can't do, shoot a police officer, hold a gun on the guy's head who simply showed up. He's just a metal scrapper, and it's in the indictment. I'm not proffering. It is in the indictment. You can't hold a gun to a guy's head because he happened upon you and hold a gun to his head with a deadly weapon, by the way, so ag assault. You can't shoot fireworks at EMT and firefighters. You can't burn down or try to burn down buildings. You can't burn up the police cars of the Atlanta Police Department. You can't destroy construction equipment. You can't threaten and terrorize people. You can't do those things. And if you do those things, and you then also agree with others to take the steps and commit the other elements of conspiracy to commit RICO, yes, you have committed a RICO. And it's that basic. This is not about what they believe. This is about what they did. And what they did, not to the police, just to the police, not just to firefighters, not just to EMTs, not just to law-abiding citizens who work and have built companies and had contracts to have something to do with this, or in some way to build or construct, to clean or whatever, the police public safety training center. It's a mouthful. It is not, in the end, it is about the criminal actions that they took, that they agreed to take, that they knowingly understood that this group and this enterprise was going to take. It is about that, and that is what the indictment charges. Now, does the indictment charge a pattern of racketeering activity? And I need my glasses. Excuse me, Judge, apologize. And bear with me, Judge, if you will, please. This particular issue within this case is a little bit convoluted and complex, as seems like everything to do with RICO charges. But I'm going to start, Judge, with just pointing out, and some of these cases have been cited by the defense in their motions, but Borders v. State, 270 GA, Georgia, 804, 1999, the court said, the Supreme Court of Georgia said, an indictment apprises the defendant that he may be convicted of the crime named in the indictment, of a crime included as a matter of law in the crime named, and of a crime established by the facts alleged in the indictment regarding how the crime named was committed. And an indictment is void if it fails to establish or charge a necessary element. Second premise, Judge, is while a defendant may desire greater detail, and this is in specifically English v. State v. English, 276 Georgia 343 at 346. Specifically, I know that they want more detail. They want everything and anything that we're going to argue, allege, our thought processes, how we plan on and strategizing for this trial. Yes, they want that. But in English, the Supreme Court of Georgia said it is not required that the defendant get every detail of the crime. In State v. Wyatt, 295 Georgia 257 at 263, and here is, I know this goes back to what you mentioned already. However, Georgia Supreme Court says, instead, it's not necessary that the indictment contain everything they need to know. It's not. Instead, additional details the additional detail desired may be supplemented by pretrial discovery he or she receives and any investigation their counsel conducts. And so it is interpreted and it is anticipated for the obvious reason. I don't need to keep reiterating that. It's blatant. We don't have to allege every single fact that they may want to know in the indictment.
Let me stop you right
Yes.
there, Ms. Stacy.
Yes.
Two things.
Yes.
One, I'm gonna cite from Kimbrough, which cites from English.
Yes.
To be clear, we do not mean to suggest that a RICO indictment must contain pages and pages of extensive detail about the connection between the enterprise and the pattern of racketeering activity. We hold only that the sparse allegations of this indictment, which says nothing at all about the nature of the connection, are insufficient to enable the defendants to prepare for trial. And in that regard, let's talk about, hey, can you conspire with people that hold guns to scrappers' heads, etc.? No, but if you're Mr. Liberto, for instance, not picking on your guy, he is named in one overt act, number 143. That on or about January 18th, 2023, he did attempt to occupy the DeKalb forest with camouflage, camping gear, and living supplies. I don't know if you've been out on Martin Luther King Jr. Drive, but there's folks out there wearing camouflage with camping gear and living supplies. So any homeless person in that park should be part of this RICO?
No, Judge, not unless there is.
Not unless there's a nexus to the RICO. Where is it?
In the allegations, Judge?
This was done to prevent the construction of the Atlanta Public Safety Training Center. That's what you're going to point to.
Yes. And the introduction that talks about the direct actions as well as the common purpose. And I'll go back, Judge. You're going to ask me for a cite, but let me say it and then I'll go find my cite with the court's permission. The bottom line is that one of the things we will have to prove is not that each defendant agreed ahead of time or then later committed predicate acts themselves. So what we will have to prove at trial is that the defendants knowingly joined a conspiracy that they knew had a common purpose of committing predicate acts for the goal of the enterprise in this situation. I'll just apply it to this case. And so an overt act is alleged against Mr. Liberto. That's all we have to allege in the indictment. And again, I'm not saying that the indictment couldn't be better. It could, of course, any indictment. But is it sufficient to put him on notice? Yes. the indictment tells him, or tells them all, that what the DTAF, the Defendant Atlanta Forest Enterprise is, where it got its beginning, some of the things that surrounded it, how it's structured, it does allege that, how it is financed, all of that. And then it says, these defendants, each individually and as a group, and as parties to the commission of the crime, conspired to commit RICO, and the law will be that we have to establish, and then it alleges the predicate acts. So while I understand that he's charged in one paragraph, that's his overt act. And we allege that it's in furtherance of the conspiracy and that it's in furtherance of the purpose of the enterprise, more important. And Judge, that's what we have to allege. Now, that's not all we have to prove or given, but that is what we have to allege. Does that answer your question?
It's an answer.
Okay. And so, as far as going back to the issue of whether there's sufficient do you have other questions about the stuff I've talked about before I move on? The issue of whether there's predicate acts, and we've argued this before, Judge, but let me hit a few more points. One is and Mr. Samuel didn't argue it, but I'll go ahead and point it out, that it is not simply just within count one that the court must look. The court must look to the entirety of the indictment along with the statute, that State v. Bear 303.
The Kimbrough case that got overturned seemed to say otherwise.
Well, so.
It said, because that was, the Court of Appeals was like, well, if you look at the whole indictment, you get the main picture. And the Supreme Court said, no, that's not how it works.
So Judge, for example, Sanders, which is a 2022 case, which is cited by the defense, 313 Georgia 191 200. When an indictment charges a compound felony, and maybe that's the issue. This is a conspiracy. Maybe that's the issue. I would need to look back at Kimbrough. I apologize.
Because there, Kimbrough, the Gwinnett County folks took an indictment, and they incorporated counts 5 through 20 and then 25 through, they incorporated the counts into the RICO count. And while the Court of Appeals thought that was fine, the Supreme Court said, we disagree. And I understand the state's argument is, hey, that's why we put all these overt acts into count one.
To put them on notice, and then the elements are filled out with the remaining count, or 2 of them at least. And that's not my only argument, Judge, but Sanders, was John, a conspiracy case? Because I don't know.
Sanders a murder case.
Okay, well, so if it's direct murder, Judge, then the distinction, then I can answer you what the distinction is. The distinction is that when an indictment charges a compound felony, that is different, or a compound crime. And are you looking, should I just hush and let you read Sanders real quick?
No,
okay. Basically, Sanders stands for the proposition, and it's well adopted, it's not in question, that when an indictment charges a compound felony, such as conspiracy, the count charging the compound offense must contain the essential elements of the predicate offense, or the indictment must contain a separate count charging the predicate offense completely, or the indictment must elsewhere allege facts showing how the compound offense was committed. And a challenge that a count in the indictment must be vacated because it did not allege the essential elements of the underlying offense is a challenge to the form. Anyway, so in this, we have to prove that the defendant conspired with one or more people to conduct or participate in the Defendant Atlanta Forest through a pattern of racketeering activity, and that one or more of the co-conspirators committed overt acts in furtherance, which goes back to somewhat of what you mentioned before, Judge, and technically, we don't have to prove that each defendant or allege actually did the overt acts. One of the co-conspirators must do an overt act. So as to Mr. Liberto, and I'm sorry to jump around, but as to your point about Mr. Liberto earlier, we've alleged a conspiracy, so every single one of those 225 overt acts are attributable to him because, once we prove, of course, but in allegation, because he is alleged co-conspirator, and he is responsible for the overt acts of his co-conspirators. That's it. Again, we do not have to allege that an individual defendant committed racketeering acts, but rather that the defendant committed overt acts in furtherance of the conspiracy, and those acts don't even have to be crimes. So, we do not have to allege or prove that the defendant agreed to that he himself will commit predicate acts, and I'm going to cite this 2025 Jordan versus State 375, and Judge, I have some of these cases if you want copies, but 375 Georgia App 552 2025 case, that is citing the Cotman case. And Jordan says a person may be found guilty of RICO conspiracy if they knowingly and willfully join a conspiracy which itself contains a common plan or purpose to commit two or more predicate acts. They don't actually have to intend to commit the acts themselves. Now, as to whether we alleged predicate acts, one of the most important aspects of the RICO statute that I think has been missed, and not just by these defendants, but a lot, is that the plain reading of racketeering activity under 1314.3 and its many subdivisions leads to the conclusion that has been adopted by the Supreme Court of Georgia.
1614.
Excuse me. Probably gonna do some things like that. I apologize, Judge. 1614.3. That not every act of racketeering activity actually has to be a full and self-contained crime. And so as the court knows, I'm gonna go through it for the record, that we have to allege a pattern of racketeering activity. And under 1614.3 subsection 4, we have to allege either at least two acts of racketeering activity in furtherance of one or more incidents with the proper relationship, and I'll just abbreviate it that way. Or we have to allege that they engaged in one or more acts of domestic terrorism. And then racketeering activity, so it's one of two ways. Either it's at least two acts of racketeering activity, or at least one count, or at least one accusation of domestic terrorism. So when you come to it, how is racketeering activity? And this is where it gets interesting, Judge. Yes, everybody knows about 1614.3.5a. Everybody is aware of it. It says that racketeering activity includes to commit, attempt to commit, to solicit, coerce, intimidate another person. And then it goes on to say, gives, I think it's 43 categorical or categories of criminal offenses. So for example, assault, and then it'd be any of those assaults under that article and chapter. But that's one way. B is the second way. So 1614.3.5b says that racketeering activity shall also mean any act or threat involving, so murder, robbery, things of that nature, arson, and felony obstruction of justice is included. Well, arson and obstruction of justice, which is punishable by imprisonment for more than 1 year. So, with the plain reading of that means that if we allege in our indictment domestic terrorism one or more time, two, adequately, two, predicate acts under 5A, which would involve the criminal offenses, or three, acts involving arson or felony arson or felony obstruction of justice. That if within the entirety of our indictment we have done that, then we survive demur. And I'm going to give you the case that specifically says that 5B includes not only or it adds to the list of criminal offenses by saying acts or threat involving. And that is in 2005, it's Dorsey v. State, 279 GA 534 at 540 through 541. And in that particular case, Judge, the state had alleged multiple different paragraphs of predicate acts and, for the racketeering activity. One of those was, I think, paragraph 5. It doesn't really matter. They had a paragraph, and in that paragraph, they alleged that defendant, let me get it right, committed acts involving murder, which is one of the allowed crimes. And then it says, in that he met with 4 co-conspirators for purpose of planning, that the conspirators conducted surveillance and obtained firearms, that Dorsey covered for Cuffey and that when Cuffey was questioned by law enforcement, and that Dorsey employed co-conspirators in the sheriff's office as consideration for their participation, and, lastly, that he discussed alibis. None of those were criminal offenses. And so what the court in Dorsey said was that, and specifically, that Dorsey argued that those were not sufficient because they didn't establish all of the elements of a criminal offense, and the court rejected that and pointed out that 1614, 35B includes acts involving. And in saying so, they actually reference and cite to a case, United States versus Miller, it's in the other case, which says, interpreting the federal RICO statute, defines racketeering activities as encompassing any act involving murder to include an act which need not be murder so long as it directly concerns murder. All that to be said, under this acts involving, all right, we do not have to allege that the defendant or defendants committed an act of arson. But we do allege that. We don't have, that's one way. We do not have to allege as a separate, fully set out accused charge they committed felony obstruction. Under B, according to the Supreme Court, and according to a plain reading of the statute, which differentiates itself from A, we have to allege acts or threats involving a narrow amount of, narrow classification of charges, but one of those charges is arson and another is obstruction with a modifier that it has to be felony. So felony arson and felony obstruction. So, again, I cite to that case as adopting that practical and plain reading of the statute. And so those are the 3 ways we can do it. And so going back to what I indicated earlier, Judge, bottom line is you have to read, the question becomes, is within count 1 or within count 1 referencing other counts, or basically are there facts anywhere in the indictment pulled together that can establish the racketeering activity? And my assertion is that we have done all 3, and just for the record. All right, under 4B, first of all, under 4B, if we sufficiently allege domestic terrorism, one-time, done deal, pattern of racketeering activity is alleged. You don't have to allege, unlike the other issues, you don't have to allege multiple incidences of domestic terrorism activity. You have to set it out fully and completely, but only one time. And the indictment does so. Section 2, paragraph 152 of count 1, in the overt acts that include predicate acts by the language of the indictment, expressly stated, states in honor about January 21st, 2023, Najee Gear, Madeline Fiola, Emily Murphy, Francis Carolyn, Ivan Ferguson joined the night of rage in Atlanta, caused arson and property damage, and thereby committed the offense of domestic terrorism. Now, obviously, as far as domestic terrorism, that doesn't lay out the elements of domestic terrorism. The state's not saying that. However,
Slow down, Ms.
yes,
Dixon.
I'm going too fast.
I know you're going too fast for Mr.
Yes, I apologize.
So you're going to 162?
Yes. Oh, 152.
50. Not to put Mr. Roberto on the spot here. But that post dates is 1 day in the park?
Very specific.
I'm sorry, Judge, I apologize, I can't.
Okay, Mr. Liberto is alleged to have camped on January 18th of 2023. The predicate act of which you speak in paragraph 152 occurred on January 21st, after Mr. Liberto went camping in DeKalb County.
Right, it's an ongoing, continuous litany of activity, and so, I see what you're.
So how does that tie him in? You gotta show how that ties him in, because if somebody goes camping and then 3 weeks later somebody burns something down,
So it's really
so if I go buy an Italian ice at a mafia-sponsored parade, I'm cooked,
no, no,
okay?
absolutely not. If there's evidence, however, that beyond what overt act, again, we don't even have to allege an overt act, but we.
I paid $1 for that Italian ice.
But then that might have been a crime, because that sounds really cheap. You know, what they say about, it's too good to be
It was a
true.
mafia-sponsored event.
Okay, but if it's too good to be true. Sorry. So bottom line is, Judge, no, obviously, because there's no evidence of other, well, if that's all you did, okay?
How's he on notice? That's his point. How am I on notice that camping furthered this conspiracy?
Because he's alleged to have. He's alleged, and it's explained. And now given, there is not a specific for each of these 62 argument or about how the state knows what it knows about Mr. Alberto, for example. But it accuses and alleges, which is what we're here for. And it says, Mr. Alberto, we are telling you to be on notice that you are accused of conspiring to do these things and to commit this RICO act. And then, of course, how RICO is defined, that comes from the statute, it comes from case law. But maybe this answers your question, I'm not sure. The bottom line is, Judge, he doesn't have to have agreed specifically to certain criminal acts. He has to have agreed that predicate offenses or acts, not offenses, not just offenses, predicate acts will be committed in, these words get so overlapping, but that predicate acts will be committed in pursuit of the purpose of the enterprise. At least 2 will be committed. He has to do so knowingly. And the conspiracy itself, or the enterprise itself, has to have a common purpose. And that's what we have to prove. So while one overt act is alleged in the indictment, that is not the extent to which the state has accused him of being involved. The state has accused him of conspiring to commit RICO, which 2 or more acts is in the indictment. So that's one act. Let me keep going, which is after the fact, but it is a continuing enterprise. And I understand what you're arguing. Your argument is, okay, well, if
I'm not arguing, I'm just
no,
pointing out
excuse me, your
facts.
point is, if he was in the, but that's not the only, but again, it's not the only incident that he's aware of, or he was involved in, or that we have information on.
How does he know that from looking at the indictment?
Because he's accused with conspiring to commit, and that he knows at least 2 predicate acts occurred, or conspiring to commit 2 predicate acts, basically. And so That's how he knows, because he's charged with it.
Go on.
And again, Judge, he doesn't.
Hey. You laugh, you leave. It's real simple. It's real simple. Sheriff, next person that makes a noise, gone. You wanna giggle out in the hall? Fine. We're not doing that in here. A little decorum, folks.
And people can giggle and people can laugh and.
Not in my room.
Well, they can. Bottom line is, Judge, we don't have to even, we don't have to allege or prove that he committed an overt act. We don't have to allege or prove that he committed a predicate act. We have to allege and prove what is alleged, which are the essential elements of conspiracy.
You don't have to prove that he committed an overt act.
But he or one of his co-conspirators. Yeah.
So you don't have to prove he did anything.
No, well, I mean, not an overt act. No, we do not have to allege or prove he committed it. It's he or any of his co-conspirators. That's the law on this conspiracy.
You don't have to prove that Spencer Rivera did anything? I think that's a good
I'm
time for
sorry,
lunch.
predicate act.
That's a good time for lunch. See
No,
y'all on
predicate
Fox.
act. Let me correct that, predicate act.
Sure. After she talks to me.
You also use the door right here as well.
administrative, witnesses for certain motions. Does the board have an idea about what time we're going to break today? I'm not asking for a particular time, just for my own plan.
I mean, I wasn't planning on doing it late, 5?
Unless we're in the middle of something.
Yeah, I mean, unless 5, give or take where we are in the process.
I appreciate that, Judge. Thank you.
You guys got all week, so I don't feel the need to go late till we start to get close to the end. Okay, you ready, Mr. Forsythe?
But
All right, so, and these are witnesses that, Mr. House is gonna walk here. Okay. Ms. Dixon, you were up here explaining to me how your indictment is good.
Yes, Judge. Let me, if I can first correct myself, apologies, yes, I'm a little tired, regardless. Overt acts must be alleged for each and every one. I argued that to begin with and then kept using the wrong words. I'm referring to predicate acts. So correcting that, Judge, forgive me for that. So understanding that, I think the other question the court was asking me, I think, is how the defendant, for example, such as Mr. Liberto, knows, based on our indictment, that he is alleged, or how is alleged that his overt act was part of the RICO conspiracy. And I'm just going to, going back to those things, Judge, and I know I said it overly simplistically, because that's what's in the indictment, because that's what he's charged with. But as far as how does he know, how is he put on notice, in the paragraph with Mr. Liberto, January 18th, 2023, reading from it, excuse me, page 81 of the indictment. Mr. Liberto did occupy the DeKalb forest with camouflage, camping gear, and living supplies. This was done to prevent the construction of Atlanta Public Safety Training Center. This was an overt act in furtherance of the conspiracy. And when you go back to the introduction paragraph, in paragraph B, again, it specifically says that the enterprise within the Atlanta forest coordinated, advertised, and conducted direct action, and that direct action, I'm not reading directly, but included certain crimes, including arson, destruction of property, attacks on people, and law enforcement officials, gun violence, etc. So when you read the indictment in its entirety, my contention is, or the state's contention is, it puts the defendants, all of them, on notice of exactly how, without not every detail, but that's not what's required, but they are on notice how we are saying their act, their overt act, tied into the conspiracy. So that said, Judge, moving back to, I think I had gone through and articulated, and was at the point where I had articulated that the Dorsey case, as well as a plain reading of 5B, made that distinct, separate and distinct from 5A offenses, which bears on the interpretation. And specifically, Judge, I've already given you that cite, but that defendant argued that his indictment was not sufficient because those preparatory acts, or those the acts involving murder, did not constitute offense, and that every predicate act must be a underlying criminal offense. That's been argued repeatedly in multiple motions. And in Dorsey, the court says, Georgia's RICO statute, however, belies that claim. And then it goes on, as I mentioned earlier, to talk about 5B and how 5B is distinct because it does not require that the state allege or prove the full commission of an offense of one of the narrowed or narrower categories of offenses, but rather 5B says that for these certain crimes, arson and felony obstruction included, felony arson and felony obstruction included, that it is sufficient for racketeering activity for the state to allege and or approve, acts involving, or acts or threats involving arson and obstruction. So, all that to be said, going back to my hopefully otherwise sensible argument without misstating the law regarding overt acts. If we, under the Georgia RICO statute, if we establish, allege,
So wait, so 5B
Yeah.
says his overt act, and I'm sorry to put Mr. Liberto, he's just the example du jour.
Great example, Your Honor.
His act, going into the forest,
Mhm.
of occupying,
Yes,
attempt to occupy, that involved an act involving not the threat of murder, kidnapping, gambling, arson. It involved the threat of what?
let me clarify, Judge.
Because, okay, if you're gonna say 5B, that's fine. This is a 5B. This is a racketeering activity under 5B. It's an act involving, it's not necessarily the act itself, I understand that, that's your argument. But how is he supposed to know, is that involving murder, kidnapping, gambling, arson? Which one is it? How is he supposed to know which one he's defending against?
Let me clarify. I am not saying that the overt act alleged against Mr. Liberto is in fact the predicate act. I am saying that I will say his overt act is not one of the predicate acts. It does not fall within the definition of 5A or 5B or domestic terrorism. And so, no, I'm not arguing that. I'm arguing that as far as Mr. Liberto goes, that Mr. Liberto is put on notice as to the crime in which he's charged and the overt act that he is alleged to have participated in, and, which was your question, I think a question that I was trying to understand, and how that overt act is charged to be in connection or the nexus with the underlying criminal conspiracy and the enterprise. And my argument with regard to Mr. Liberto is that when the indictment alleges that he did this in the intro paragraph, that this enterprise did certain crimes in furtherance of, I'm just gonna say it that way, or to get to their objective, okay? That talked about the nexus between the overt acts and each and the underlying purpose of the enterprise and the RICO type activity. So,
But if you've got the purpose in paragraph B,
Yes.
is to prevent the construction of the Atlanta Police Public Safety Training Center, right?
that's part of it. I think it's essential.
And Shadowbox Studios.
Yes,
And promote anarchist ideas.
that's part of it. That's part of what's alleged.
Okay, but Shadowbox Studios and APD Public Safety Training Center.
Yes.
And I hate to backpedal here, but doesn't that go back to their date range argument? Because nobody knew about Shadowbox or Public Safety Training Center in May of 2020.
Our argument.
And that is in the indictment.
Yes.
That is the stated purpose of this corrupt organization.
So, yes, Judge, yes. And
So why are we predating that? Because they could not have been Shadowbox Studio, Public Safety Training Center, not a thing in May of 2020.
so
And like I said, I hate to backpedal.
No, you're fine. Of course you're fine, excuse me, Judge. No.
My job is to be curious.
My argument regarding that is that the enterprise, which had this goal of this trifold goal, and that the evidence will bear it out, but that the argument is that the conspiracy, notably, Judge, that the conspiracy, okay, existed from those dates. And let me make sure I've got let me be technically accurate. Excuse me. that they were associated with an enterprise. And you're, I think, saying, how can the enterprise with this purpose exist before the public announcement, before? What I will tell you is that the date range of that conspiracy is alleged based on the information that we obtained through evidence that we received during the course of the investigation, whether it be statements of an alleged co-conspirator, which were not testimonial, so don't invoke the confrontation clause, but statements of a non-indicted or statements of a masked co-conspirator, we'll say it that way. We believe we know who it was, but regardless, statements of a masked co-conspirator. And again, Judge, under that logic, under their argument, the Network for Strong Communities, which was a core part of this whole thing, I mean, the record shows that they were created, incorporated in August of 2020. So my argument is that while the indictment alleges a date range, it then follows up with specific dates that actions occurred. And so as far as notice and all the case law they cited about notice, every single act charged as either predicate act or overt act has a specific date. So none of those cases are applicable to us.
Is Atlanta Forest the corrupt organization, or is Network for Strong Communities the corrupt organization?
Atlanta, in the indictment, it's defend the Atlanta Forest. Network for Strong Communities is part and parcel of it. It's very convoluted, but it's part and parcel.
I think that's exactly what the defense is telling me, and they're asking me, it's way too convoluted. I look at it, I can't see it.
Well, I'm not saying that the indictment can't be seen. I'm saying that the facts of the case are convoluted. Because, I mean, that's part of the intent. I won't get into that. But it is, we alleged the beginning of the conspiracy on that date based on evidence we received to include a co-conspirator's, unindicted co-conspirator's statement. That is part of why we included the date that we included. The specific overt acts are then alleged, and we're going to be restricted to allegations of those overt acts. However, Judge, I mean, under anybody's rational, just common sense approach, before the first overt act, an enterprise can exist. I mean, that's just common sense. I mean, it can exist before they first take an act, or before they take an act that we charge. And so, yes, we have alleged that the enterprise and the conspiracy.
I agree with you.
Yes, okay.
An organization can exist.
Yes.
Now let's talk about purpose. Okay?
Okay.
It can exist. They could have, Atlanta Force could have been in existence since, I don't know, 1900. Public Safety Training Center didn't come to existence then. I mean, how are they acting with a purpose for something that doesn't exist?
Judge,
Or
it can be in the planning stages of it. They may know it's coming. I mean, and probably Mr. Fowler may speak better to this, but.
well, I mean, he was up here saying, hey, that's when they heard about it, and that's when Mr. Hetzel was like, okay, fantastic, let's hear it. Where is that in the indictment? Mr. Hetzel, is I wrong there?
To clarify, I'm asking for the state to produce a witness or some other evidence that somehow gets us to May 25, 2020, instead of the first overt act listed, which is July 2020, instead of August 2020, when some organization incorporates, instead of September 2021, when the land swap happens.
So Judge, my first contention to all of that is, in order for us to need to put a witness on, to explain why it can't be further delineated and narrowed, it has to be determined that it is insufficiently broad. And again, this is an indictment. It is about what the accusation is. I've explained to the court why we accused it the way we did, alleged it the way we did, which I don't think is even necessary. I mean, it is not an overbroad. We have to allege a pattern. Again, all of those cases regarding, and I haven't read the one that he provided earlier. I have not read that. But I did read a short blurb. The child-involved child crime cases, Judge, literally part of the rationale behind that is that a defendant charged with rape or incest, it's not permissible for the state to just generally allege sort of this pattern of conduct, and that that's not fair. That is the exact opposite of what the law requires for us to allege and prove RICO. RICO requires us to allege a time frame in which the conspiracy exists, because we must allege the pattern of racketeering activity. As to that one case whose name I do not remember, I pulled it up, I didn't read it in full, but I can tell you in the holding section, one of the things it said was, it's not valid because the 43 predicate acts, or the 43 separate acts, there was no date given. That's the exact opposite of what we've got here. So we have a date range that we say in our indictment. I'm not saying what's going to happen at trial, but we have accused these defendants of participating and conspiring in this enterprise, or while associated with this enterprise, in RICO activity between these two dates, and then allege specific instances of overt act and predicate acts with specificity and dates. In that scenario, we don't get to put on a witness because they haven't satisfied the burden that we would need to narrow it. And so that's the state's position with regard to that. Now, moving back, and I understand why it was a little discombobulating when I started back in on the indictment. However, let me go back, Judge, and I was, before the break, talking about how the indictment alleges racketeering activity, or a pattern of racketeering activity, and I started off by saying all we have to do is sufficiently allege a single incident of domestic terrorism to establish a pattern of racketeering activity. In section 2 of our indictment, in paragraph 152 of count 1, we allege that on January 21st, 2023, Naja Geyer, Madeline Viola, Emily Murphy, Francis Carroll, and Ivan Ferguson did join the Night of Rage in Atlanta and caused arson and property damage, and thereby committed the offense of domestic terrorism. However, going back to the Sanders case, Judge, which talked about compound crimes, conspiracy being a compound crime, that you can look to the other counts for the rest of the details to support your predicate act offense and whether they've been put on notice. And corresponding count 2 of the indictment further sets forth all of the elements of that exact same domestic terrorism. It relates back to it, it follows the language, same date, same individuals involved. So there and then, under the law, whether people think it should be enough or not, but under the law, we have alleged that as an overt act, these participants, these four on this date, participated in domestic terrorism, and then in count 2, as allowed by Sanders in a lot of other cases too, but Sanders in 2022, then we then supply the necessary factual specificity, or excuse me, alleged specifications or specificity to the domestic terrorism and how they committed it. So that's one. So right there, Judge, we've established a pattern of racketeering activity. Then you get to, did we establish a pattern of racketeering activity under 1614.3.4a, which is the subsection that says at least 2 acts of racketeering activity in furtherance of one or more incidents, schemes, or transactions that have the same or similar intents, results, accomplices, victims, or methods of commission, or otherwise are interpreted by the are interrelated by distinguishing characteristics and are not isolated incidents. And then it goes on to give you the time boundaries of when those can occur. Racketeering activity then gets defined. So what are incidents of racketeering activity? And this is where I was talking earlier. Racketeering activity includes two different things. One is the commission, attempt to commission, etc., of enumerated offenses, and it's like through 43. And it's not just 43 offenses, it's 43 categories of offenses. So for example, assault, under the chapter and article, and so it would be any of those assaults. But 43 categories of offenses. Or B, which is what I was talking to you earlier about the fact that if the court, the indictment can allege acts or threats involving felony arson and felony obstruction of justice. And so if we have then, within the entirety of this indictment, alleged either, we already argued that we alleged domestic terrorism, so we're done with pattern of racketeering activity. However, if the court deems otherwise, then have we done it through one of those 43 categorical crimes under A, which would have to include all of the elements of those underlying offenses because they are, in fact, the commission of an offense. Or under B, which is allegations of acts or threats involving the arson and the felony obstruction. So, and I quoted that case to you already, Judge, so we won't reiterate. So going to the specifics, and I'm going to start with A, which is the racketeering activity that is in and of itself a crime. And the state asserts to the court that the indictment in its entirety sets out multiple allegations that are sufficient to establish an assault. And this goes back to the beginning, Judge. I quoted, I think it's still Sanders. Yes, Sanders v. State, where it says the indictment must, one of the three ways is if the indictment alleges elsewhere facts showing how the compound offense was committed. So one of those three ways, either in count one, setting out all the elements, and the elements are all set out in count in the entirety of the indictment, or we've alleged sufficient facts to establish the elements essentially of the compound crime. So starting with assault, the state would assert to the court that the indictment in its recitation of 225 overt acts that specifically the indictment says include racketeering activities, that we have alleged assault in paragraph 72, in which it gives a certain date, says specific individuals, Abigail Skapiak, Philip Flagg, Madeline Kodak, Brooke Quartermont, Mariana Hoyt Lane, and Anna Gypsy Lee, and two unindicted co-conspirators did throw Molotov cocktails and glass bottles at police officers. Two, the state asserts that we have alleged an aggravated assault in paragraph 110. On November 8, 2022, Abigail Skapiak did provide information to a masked unknown individual that held Richard Porter, a metal scrapper, at gunpoint in Encroachment Park, thus committing aggravated assault against Richard Porter. The third example of an assault is paragraph 116 on...
She provided information.
Information to the person, yes.
What time of day it was, what kind of information? She provided information to somebody committing the crime.
So somebody who held him at gunpoint, yes.
Okay. And what kind of information was that?
It's not alleged in the indictment. I mean, I can tell you that and it's in the discovery, but it's not alleged in the indictment.
So how is Ms. Skapiak supposed to look at number 110 and go, I don't prepare for that. I brought out information.
I mean, I think she has to know what she needs to defend against, and I think it puts her on notice that what she needs to defend against.
Provide information to wit, the information provided to an unknown individual.
It could be more specific. I'm not arguing with you about that. Our contention is that it is sufficient to put them on notice and sufficient to plead a predicate act.
You allege it as an overt act, not a predicate act.
Well, it's both, and it's alleged as both. It's, I mean, it,
This is an overt act in furtherance of conspiracy.
yes, but at the heading,
Thus committing an aggravated assault.
yes, but at the forefront of those 225 paragraphs, in part 2, it says, the defendant committed overt acts to affect the object of the conspiracy, which include acts of racketeering activity as described below.
And you're going back to paragraph B. Is that where you are?
Part 2, no, it's the beginning, excuse me, Judge, let me pull up the indictment real quick so I can make sure that I am directing you to the right portion. Do you have the indictment pulled up?
I've got it pulled up. Part 2 of the indictment?
It should be right above the beginning of the recitation of the 225. It's part 2.
Page 49.
Thank you.
Defendants committed overt acts to affect the object of the conspiracy, which includes sets of racketeering activity as described below. Acts of racketeering activity as described below.
Yes.
Okay.
And I think you're getting to something that will be covered in a later part. So, Judge, then we move to, I think I left off with paragraph 116 on December 13th, 2022. And I'm going to just kind of abbreviate instead of exactly quoting, but Carol, Tilbury, Olson, all named defendants in this indictment, did throw rocks, a bottle, shoot fireworks at firefighters and EMTs. Paragraph 121 is another simple assault. December 13th, 2022, Serena Hotel did cut a rope in an attempt to cause an arborist to fall during climbing. This is an overt act in furtherance of the conspiracy, which is at the end of every one of them because it's required for us to allege that they overt acts are in furtherance. Fifth incident of assault, aggravated assault alleged in the indictment, is paragraph 124. December 14th, 2022, Ariel Ebal did approach the cab law enforcement with a rifle, knives, and pistol in a threatening manner in an attempt to intimidate the officers, thus committing an aggravated assault against the cab law enforcement. So, right there, based on that, our allegation or our assertion to the court is that first and foremost, we established domestic terrorism. We supplied the necessary elements and details in count 2, which is completely permissible under the law of the state, and because it's a compound crime, and that we have also in these predicate acts set forth the necessary facts to allege either assault or aggravated assault. Then judge number 27, or the 27th, because it's not number 27, it's like XXLL, whatever it may be. The 27th category or list of offenses under 5A that can be alleged as racketeering activity is influencing a witness. And the elements of that are, it shall be unlawful for any person knowingly to use intimidation, physical force, or threats to persuade another person by means of corruption or attempt to do so, with the intent, B, to cause or induce any person to withhold testimony or a record, document, or other object from an official proceeding. And that's obviously not the entire statute, Judge. I have sort of culled it down to include only the portions of the statute that we assert are relevant to our indictment. And so the state asserts to the court that the indictment contains 41 separate allegations of co-conspirators using threats with the intent to cause and induce construction officials to withhold records, documents, or testimony in official proceeding. Those paragraphs are 5 and 6, 8 through 11, 13 through 15, 17 through 24, 32 through 37, 71, 103, 125, 127, 128, 130, 133, 134, 149 through 151, and 158 through 164. Each one of those paragraphs sets out every element necessary to prove and charge influencing a witness under the section of the statute that I read to you earlier. I know that there was an argument from somebody, I'll just go ahead and address it, that we did not allege that there was, and there in fact wasn't a pending proceeding, and I'll provide the statute to you, but the statute just directly states that there is no burden to prove, much less plead, that there is an ongoing pending proceeding. So based on that, we allege those things, Judge, according to the state, we have alleged domestic terrorism, so check off pattern of activity being alleged, pattern of racketeering activity being alleged. We have alleged multiple counts, I think it was 20-something counts of assault, either aggravated or simple, but then we alleged 41 distinct allegations of influencing a witness in the paragraphs that I referenced to you before. So those are our 5A offenses in which we assert that we have met the burden through Sanders, and the Sanders standard, I don't remember what Sanders would say, the Sanders standard, that all of the necessary elements that are provided to the defense through either recitation of the statutory language, or recitation of facts that would support the elements of the offense or prove the elements of the offense. However, we're not limited to those 5A offenses because of subsection 5B. And again, I read to you from the case, it is a direct Supreme Court of Georgia case that says 5B, racketeering activity, it does not equal a criminal offense, rejects that notion and says it's different. And you don't have to prove that they committed murder, arson, obstruction. Those things are under 5A. But it provides a different and additional way for the state to allege and later prove racketeering activity through acts or threats involving felony arson and felony obstruction. So where do we allege those, Judge? Our contention is that acts or threats involving arson are alleged in paragraph 1, where we allege that a Molotov cocktail was thrown at Georgia State Patrol headquarters, and that is an act or a threat involving arson. Not that we've laid out the offense of arson, but it's that we have alleged an act or a threat involving arson. Paragraph 130 is an act or threat involving arson when it alleges on or about January 1st, 2023, Cox, McLean, and Patterson, and again, I'm summarizing a little bit. They published these scenes blogs posts claiming responsibility for an arson of a bank, and thereby made threats against construction officials committed and influencing a witness, the rest of that paragraph. So we've alleged acts involving an arson when they use, or excuse me, threats. We've alleged threats involving arson when we allege that those 3 individuals made a post and claimed credit for an arson and then used that arson to threaten and intimidate witnesses. That's our allegation.
I'm looking at 1610-93.
Yes.
A person who, with intent to deter a witness from testifying freely, fully, and truthfully to any matter pending in any court,
Yes.
in any administrative proceeding, or before a grand jury, communicates directly or indirectly to such witness any threat of injury or damage to the person, property, or employment of the witness, or to the person, property, or employment of any relative or associate of the witness, or who offers or delivers any benefit, reward. First part was the stake, now they get to the carrot part of it. Okay, you were saying publishing this stuff was an indirect communication.
Judge, I'm saying that it fits under, if you'll give me 2 seconds. under, it shall be unlawful for any person to knowingly use intimidation, physical force, or threats to persuade another person by means of corruption or to attempt to do so, or to engage in misleading conduct towards another person with the intent to influence, delay, or prevent the testimony of the person in an official proceeding. B, and this is what we've alleged, to cause or induce any person to withhold testimony or a record, document, or other object from an official proceeding. And official proceeding is not just is defined, and it is not limited to court cases. I'm trying to find, there it is. In 3A, it includes hearing or trial conducted by the court of the state or its sorry. I'll just read. Any hearing or trial conducted by a court of the state or its political subdivision, a grand jury, or an agency of the executive, legislative, or judicial branches of government of this state or its political subdivisions and authorities. So it does not have to be a court case. If there is a hearing in an administrative hearing that falls within those branches of government and that type of hearing is defined in that statute, and somebody does something and threatens with the requisite intent, and that's what we mentioned this.
Okay.
So we've alleged that's one of the ways, but that they use these threats to intimidate and influence construction officials from doing the elements of the crime. I'm not going to read it all again. To prevent them from providing documents, et cetera, in an official proceeding. Now, let's see, where was I? All right. Yes. Acts involving arson, paragraph 152, on or about January 21st, 2023, Geyer, Fiola, Murphy, Carroll, and Ferguson, and this is that paragraph we read earlier, did join the night of rage, and caused arson and property damage, and thereby committed the offense of domestic terrorism. So, at a minimum, that is not only directing them to the count 2, but it is also an act involving arson. Paragraph 153, on or about January 21st of 2023, Ivan Ferguson and Naja Geyer rode together in the night of rage inside a truck with a gas can and camping gear and a climbing gear. I withdraw that, Judge. I don't think it's clear enough as I read it. I don't think that's clearly enough that it is involving. Now, it is later charged as part of the arson, and so you can argue that it is that paragraph in conjunction with count 2 puts them on notice that it is a act involving arson. However, I will go with count 2 as a definite way of putting them on notice and providing them with all the necessary details that they've been charged with an act involving arson.
It's not 153 and 154 the exact same sentence.
Let me check. Yes, I do believe there's one that's repeated. I do believe there's a duplicate, Judge. Let me check though, if you don't mind. Let me have just a moment. 153. I think that's correct. I noticed that. They're duplicative, Judge, so we can agree that one of those would be removed or struck. And then, Judge, in paragraph 155, on the same day, Carroll is alleged to possess a lighter and accelerant while attempting to break into 191 Peachtree Street in Atlanta and did commit the offense of domestic terrorism, referring to count 2, of course, for all the rest of the details. However, that plus count 2 definitely puts him on notice because count 2 explains that he was doing so in pursuit or while attempting to commit an arson, so that puts him on notice that he is thereby charged with the predicate act involving arson. Number 6, in 24 different times, paragraphs 194 through 217 allege that the different co-conspirators, so everyone is, it doesn't allege that vaguely, it says on or about March 5th, 2023, so-and-so, and so there's 62, or so it's not 62, it's however many were there. Each one of the defendants are then named, and it says they did join an organized mob and succeed in overwhelming police force, thereby aiding and abetting in the offense of arson and domestic terrorism in an attempt to occupy the force and prevent the building of Atlanta Public Safety Training Center. That, each one of those paragraphs, and then it also has the overt act language.
The arson and domestic terrorism that happened back in January?
No, no. No, sir. It's a separate date, it's a separate incident. This is, well, you don't need me to get into all the facts. This was the March 5th incident where they burned a bunch of stuff, and set things on fire. Anyway, so that specific application definitely 24 separate times against 24 separate defendants alleges that each one of those 24 co-conspirators, as alleged in the indictment, committed acts involving arson. So those are so that's 29, I believe, Judge, and I'm not the best at math, but 29 acts involving arson have been alleged. Then we get to acts or threats involving felony obstruction. We've got 27 of those alleged, Judge. That's paragraphs 119 through 121, and that's December 13th. Did issue a call to action on Instagram for forest defenders to deliver a physical response to prevent her arrest. So we allege that is sufficient to put them on notice that they are charged with an act or a threat involving felony obstruction. 120, it's the same date, same person, attached a wooden board with metal spikes to a treehouse to prevent law enforcement from reaching the treehouse. 121, the same person on the same date, cut a rope in an attempt to cause an arborist to fall during climbing. And then in 24 times, paragraphs 170 through 193, similar to the other ones I referenced with the arson, but these paragraphs say and allege that on or about March 5th, and then there's 24 different of these co-conspirators named individually in each one of these paragraphs, that person did join an organized mob of individuals designed to overwhelm police in the police force in an attempt to occupy the cab force and cause property damage. That particular, all of those, the state alleges, allege sufficient facts that would support a predicate act of act or threat involving felony obstruction of justice, Judge. So in summation, the allegation is we did not allege predicate acts. Some of them say no acts of racketeering activity. Some of them say no pattern of racketeering activity. I'm addressing whether we alleged pattern of racketeering activity through racketeering acts. And in summation, Judge, we've alleged 27 allegations of threats involving felony obstruction, 29 allegations of acts or threats involving arson, 41 allegations, slow down, of influencing a witness, 3 allegations of simple assault, 2 allegations of aggravated assault, paragraphs 155 and 156 in corresponding to count 2, allege the domestic terrorism. Yeah, that's all we have to do, one sufficient charge of domestic terrorism. And then paragraph 152 puts the defendant on notice of the racketeering activity crimes of domestic terrorism and attempted arson with corresponding counts 2 and 3. That then, so you've got 2 is domestic terrorism, 3 is arson, and count 152 puts them on notice that they are charged with conduct that then is arson or domestic terrorism, and that those offenses are later defined in counts 2 and 3, which is allowed under the Sanders case and many other cases. So Judge, as far as, the arguments of Mr. Sanders, I don't think I will have to take up court's time because many other defendants argue the same thing, and I believe that I've covered what our position is with regard to that. And again, Judge, so in essence, in response, this is not targeting or subjecting these defendants to illegal prosecution under the First Amendment under any way. And the state has sufficiently alleged for an indictment that the elements of RICO conspiracy, including a pattern of racketeering activity and the specific racketeering acts or racketeering activity that support that. Right. Thank you for your time, Judge. Do you have any questions?
All right now.
Thank you.
Do you want to follow that back up? It's your all's motion. I'll take that as the yes.
All right. A lot of issues that she raised, some of which, as I told you before, we got no briefing from the prosecution before this hearing today. So none of the cases they've cited, nothing that they've cited here today was ever previewed with the defense over the last 2 years. So it makes it a little difficult to reply to some of these. But I'm going to do the best I can. First of all, with regard to the issue of the impropriety of the introductory language, the 25 pages of the, as you put it, the Aleppo allegations, this is not a case like Mr. Fowler referred to in the Second Circuit case involving a prosecution of the Genovese crime family. Of course there are going to be allegations about the history of the Genovese crime family, just like there can be allegations about the history of the actual enterprise in this case, as opposed to going back literally hundreds of years with allegations about the history of anarchism and violent anarchism. There's a world of difference between alleging the background of the Genovese crime family in a Genovese crime family prosecution and allegations about the history of the philosophy of anarchism in the world. Second of all, the allegations in our case include all kinds of allegations from taped interviews of people who are masked and who make allegations that are never identified. And we have no idea who these people are. People making violent allegations, violent suggestions, supposedly, to members of the enterprise here. A clear violation of the Confrontation Clause, no matter how you dress it up. They can, whatever Mr. Fowler claims about where they derived this information from, I don't know, I have no idea, because it doesn't allege where they found it or gathered it. So the idea that they can present to the jury, either in the indictment or even in evidence, a masked person reading a script saying we should kill more policemen would never be tolerated in an American courtroom. So, Mr. Fowler's closing remarks where he says, we think this does go to the jury. The entire indictment goes to the jury, including this language. And these allegations by, unidentified people is a clear violation of the Confrontation Clause and due process. With regard to the suggestion that we should just simply strike it, that we could use the vehicle of motion to strike surplusage, that is actually not done very often in Georgia. It's done frequently, much more frequently in federal court, but in Georgia, it tends to be done with as an errant word or an alias that didn't, we're going to call some guy, murdering Joe or something. We can strike that kind of surplusage. We're talking about striking 25 pages of this indictment. That's what we're talking about, is the only remedy which we believe is more akin to a special demur, as opposed to, dressing up the indictment a little bit or cleaning it up a little bit through a motion for surplusage. So we stand on the position that it is a remedy, that the remedy we seek, which is dismissal of the entire indictment, go to a grand jury without polluting the grand jury with this information and inducing the grand jury, because of these masked people, you can assume that all these defendants out here are murderers
And they all advocate for murder and killing policemen, which is what the introductory language suggests with these masked people who were giving speeches. The only possible remedy the only reasonable remedy is to dismiss the indictment, grant the special demur with regard to that, and let the grand jury return a more an indictment which is more befitting a courtroom in this county and in this state. With regard to the demurs, and I'll start with where Ms. Dixon finished, which was these allegations dealing with intimidation of witnesses. If you look at the overt acts that we're dealing with here, time and time again, they talk about my clients, as well as many of the other clients, engaging in some kind of conduct to effect an official proceeding. Ms. Dixon's correct. It doesn't have to be a pending proceeding, but it has to be an official proceeding. And they've never identified, nowhere in this indictment does it allege what official proceeding was supposedly going to be impacted. And there's nothing in either the federal intimidation statutes, the obstruction statutes, or the state statutes that say you can just allege an official proceeding and we'll just let the jury decide. Because we sure have no clue what they're talking about. We have no clue what the prosecution's intending to present before the grand jury, before the trial jury, as to what official proceeding could possibly be envisioned by the defendants who were engaged in this conduct. And given their argument today, I will give you a case, a recent case. It's not in my case. The case is State versus Eastman. This is the Trump case, in which we argued to Judge McAfee exactly this issue, that there was a solicitation to the legislature. I don't know if you've ever read the Trump indictment, but the defendants are alleged to have solicited legislators to violate the Constitution by uncertifying the election. Right? That's the allegation against the Trump co-conspirators. And we argued to Judge McAfee that the indictment was defective because it didn't say what part of the Constitution do you claim we were violating. And he agreed, and the Georgia Court of Appeals agreed. And the case is State versus Eastman. The citation is 374 Georgia Appeals 484 this year. That's Judge McAfee in the trial court last year, and the Georgia Court of Appeals this year. 374 Georgia Appeals 484, granting a special demur, dismissing all those counts of the indictment. There were many counts of the indictment dismissed. Agreeing with our argument that you've got to be specific when you're talking about, what part of the Constitution you were soliciting the legislators to violate. Clearly analogous to the argument we're making here is you have to tell us what official proceeding you're claiming we were trying to obstruct. It doesn't have to be pending, it could be envisioned, but at least we have to have been thinking of an official proceeding, and they have to identify what kind of official proceeding and what specifically official proceeding we were envisioning. With regard to, Mr. Garland's going to be arguing either next, or I'm not quite sure what the order of proof's going to be here, but he's going through a lot of the special demurs that surely apply to my three defendants. He's representing someone else. It's just count after count after count where we're having to guess what the prosecution is going to try to prove, which is exactly what the office of a special demur is. The prosecution is wrong when they say, you already contested this, just look at the discovery and you can find out. Federal courts, sometimes they allow that, they allow it with a bill of particulars. We don't have bill of particulars in Fulton County Superior Court or the courts of Georgia. They have to allege the facts that are needed, not just the law that is violated. And the Jackson case that we put in our brief, 301 Georgia 137, in our brief, explains, the Georgia Supreme Court explains that a special demur can demand facts that allow us to prepare a defense. And I'll go back to the Scenes blog allegations again. And Mr. Fowler says, it's as clear as can be. We've identified every fact you could possibly want to know. You authored something and then describes the supposed statement that we authored, and it ended up on some blog site somewhere. Dozens of counts, many of them dealing with the official proceeding claim as well. And yet they never say how we supposedly authored it or who authored it, because each of those counts says some undefined number of unindicted co-conspirators and Marlon Cass and Adele McClain and Savannah Patterson all authored something that ended on a blog post. We have no idea what the actual allegation is. We can find the blog post. It doesn't have anybody's name on it. We don't know who the unindicted co-conspirators are. Apparently they don't either. We don't even know categorically who the unindicted co-conspirators are. There's no defense we can do. We could have started the trial the day after the indictment was returned, because we knew as much then as we know today. And the prosecution also says, you can find it in the discovery. You can't find it in the discovery. I went to Mr. Fowler's office, me and Mr. McDermott went to Mr. Fowler's office. Would you tell us how you have facts that show that either Cass or McClain or Patterson authored these things in the Scenes blog? I told you this morning. They gave us one piece of paper that has the Atlanta Solidarity Fund and Scenes blog on the same page. We don't even know who authored that page or what it was. It was from what they call a zine. But nobody knows who authored those or who it was a fundraiser. We have no idea that it has anything to do at all with proof that we authored it. And the Jackson case says where you need facts to prepare a defense, facts should be supplied. And just saying you authored it without giving us any information whatsoever requires that those predicate acts be dismissed. That a special demur granted. And I was going to go through a number of these overnights, but I think Mr. Barnum's going to do that and shows all the special demurs that are needed. So if I could just defer to him. Plus, it has nothing. Most of them have nothing to do with these four defendants. So it's you might fight that another day. Some of them, and I'm concerned that I may not understand the proper protocol here. I mean, there are many, many issues dealing with our three clients. I say our, my law firm's three clients that have nothing to do with them. And I'm sure you don't want to hear about, for example, the motion to suppress is still pending. It has nothing to do with these four people. It's been sitting there for about 2 years now. We have the whole filter team issues that we're working through at least, and close, but not done, resolving. But just dealing with the demur, if I can. The other thing I would point out, I want to talk just briefly about the Dorsey case. This is Sheriff Dorsey. You remember Sheriff Dorsey was alleged to have assassinated or arranged for the assassination of Derwin Brown in DeKalb County. And I represented Sheriff Dorsey, unfortunately, because I lost that case that Dixon is talking a lot about. And it does have troubling language about the definition, my definition, troubling language about the definition of a racketeering act. The structure of the statute is, and Ms. Dixon talked about this a little bit, is there's a list of 43 specific generic crimes in Georgia, including homicides, everything in chapter 1651, various sex offenses, 16.6. If you look at section 5 of 1614, whatever, it's 3, Georgia Code sections. And then if you look at 5B, it says any crime in any state involving murder, arson, and the whole list. It is clear from the legislation that what the intention was to bring in the laws of all 50 states, because RICO allows you to prosecute for crimes that occurred outside the venue. So first they identify all the Georgia crimes, including murder, including arson, including intimidating witnesses. That's all in A. And then it says, and in any state, crimes involving arson, murder, and intimidation. Because they're trying to bring in reality, another 49 states' laws in section B
Don't forget the territories.
and DC. And,
Guam.
huh?
Guam.
That's right, Greenland. No?
Not yet.
So, but listen, I'm gonna be honest, the Supreme Court didn't agree with this. And the Supreme Court agreed with Ms. Dixon, and I suppose we're gonna have to honor that here. They did say, when the statute said, and any state, even though it is abundantly clear they're trying to bring in 49 states,
It meant Georgia too.
we're one of the 50.
Yep.
So the question is how to limit Dorsey somehow to make sense, because why would you say you have to prove a predicate act, murder, arson, and then say, or any act involving murder? It's completely duplicative. There's no reason to have had Section A at all, if you're going to say any act involving murder. It doesn't say any overt act in B. And in Dorsey, they never defined what they meant by an act involving. We know what the legislature meant. It meant the crimes in Maryland involving murder, the crimes in Kentucky involving murder, the crimes in South Carolina and Alabama, because they didn't want to have to go through every code section of every state. So, but the point is that has nothing to do with the demurs that we have filed. Because none of my clients are charged with, my clients, my law firm's clients, none of them are alleged to have violated an act involving murder or an act involving any of these other code sections that they're alleged. Nor do the predicate acts say that that's what they're relying on, a 5B allegation, as she said, calls them 5B claims. None of them say that. We're just left to guess. What is the predicate? What are we defending here?
Does the indictment have to delineate between 5A and 5B? I mean,
I would think so. They have to say, they can't just, they don't give us many facts, and then they don't give us the appropriate code section. That's what Jackson says. Jackson even says you shouldn't even rely just on code section. It should be code section plus element plus facts. And, you know, if it's obvious, and sometimes it is obvious, like in Sanders with some of the counts. Some of the counts were thrown out in Sanders. I mean, Sanders has some counts that survived the Supreme Court, and other counts, I think Judge Bethel wrote the decision, other counts where he said, you allege they violated the Controlled Substances Act. You didn't say what drug. Well, I think under their analysis here today, you don't really have to do that. Just say VGCSA. But Judge Bethel said, no, you got to be precise. You got to be precise, exactly what drug. And that's for a solicitation count, where it's the predicate offense for a solicitation count. Were you with me? The defendant asked someone else to sell him some methamphetamines, and the indictment said, you solicited someone to sell drugs. And Bethel said, in violation of VGCSA. And Justice Bethel said, that's not enough. You got to identify the specific drug. Well, that's like the official proceeding in these counts. You got to identify the official proceeding. You have to be precise so you can at least prepare a defense. I'm back to surplusage for 1 second. Mr. Fowler says one of the reasons we can put it in is because it came out of their own language or their own mouths, the defendants. I seriously doubt that. I seriously doubt the accuracy of what he said there, not intentionally, but is he claiming that they have one of the defendants reciting 25 pages worth of the history of anarchism somewhere? We certainly haven't seen that in the discovery. And so I think what he's doing is he's saying we've got these masked people talking. So we're not going to tell you who said it. We're not going to tell the jury who said it. Just someone wearing a mask said, you know, during the night of rage or day of rage, we ought to kill some cops. It says, well, that's why it's in the indictment, because some masked person said it. And then he said, well, maybe it came out of books or articles. Well, let me remind you of the First Amendment and you know, the Anarchist Cookbook. A lot of people have got a copy of the Anarchist Cookbook. I bet you've got a copy of the Anarchist Cookbook in your library. But nobody would say that you're making bombs, you know, or that you believe in bomb making, or that you advocate bomb making. And we all have books in our library that we don't actually advocate for. I mean, criminal defense lawyers have all kinds of books in their libraries about the crimes that we defend against, our clients who were charged, you know, and you may remember from our motion to suppress the types of materials they seized from our client's house. The voluminous amount of books and magazines and pamphlets. Some of them were in fact written at the beginning of the century, and they're claiming they're going to use that in our trial. So strike the surplus or not, they plan to put it in anyways because it was in Marlon's library. And we quote 100 cases to you saying you can't put the anarchist cookbook in evidence. It's the same as the rap music cases. So I'm going to defer to Mr. Garland if I can, and with all due respect to these four folks, when their special demur gets raised, I think he's been invited to deal with those facts. But we maintain general demur should be granted in this case because of the various flaws with the indictment. Can you imagine, can I just finish with this? Can you imagine trying to instruct the jury consistent with everything that Ms. Nixon just said for the last 2 or 3 hours? Can you imagine trying to explain to a jury the way this indictment is framed? The intricacies of the verdict, either guilty or not guilty on count 1. How are they going to do that with this indictment?
I would look forward to reading the proposed jury charges provided by the parties.
Well, we have tried actually to start working on that. It is impossible. It is impossible. Okay? I mean, you've read the indictment, right? You've read the motions, you've read the demurs, you certainly know the statute. Can you imagine trying to explain to a jury how, take my clients who've never set foot in the forest, who paid for people, who arranged for the payment they didn't pay, arranged for payment for people for hot dogs, veggie dogs actually, that is or is not an overt act that you can use to hold them responsible, hold my clients responsible because they're paying for food. You about to ask me a question or about to be frustrated?
No, I was just about to make a Godfather reference. Marlon Brando never pulled the trigger. Marlon Brando never went on the scene.
Yeah. I think, well, we don't know about that, but but
That's kind of what RICO was originally designed for, was it not?
well, it wasn't necessarily for Marlon Brando, it was for racketeering. It was for organized crime families who have a vast array of crimes being committed by a vast array of people in various jurisdictions.
And
Yes.
how to get those people that manage to keep their hands clean.
Oh, I don't know about that. It's always been that the ringleader is certainly subject to be prosecuted. There's nothing about RICO that makes that unusual. There's nothing about RICO that says go after the kingpin. I mean, it's the same level of proof as before RICO was enacted. But, sorry, to cut you off track a little bit. The fact that my clients didn't go to the forest is certainly an issue here. They're not charged with trespassing. They're not charged with.
Michael didn't get in the boat with Fredo.
Say it again.
Michael didn't get in the boat with Fredo.
I assume there's cement shoes somewhere in there, right?
Never seen the Godfather.
Many times. All right, yeah.
Fredo doesn't make it out of the boat. Let's just leave it that way.
Okay. Thank you.
Okay, 1:30, where are we? I've got, you're in this.
Which is the motion that Mr. Garland was arguing? Excuse me.
Where?
We're at number 3 on the list, which is the motion Mr. Garland was arguing.
Number three is the general and special demurs to count 1 for insufficiency. And then number 4, if we get to it today, is the lack of prosecutorial authority.
Yes, Your Honor, for both 3 and 4, we asked to take it off the hour. Mr. Hall will be arguing number 4.
Yeah, I think you guys estimated an hour on 1 and 2 also. You guys keep time about as well as other lawyers.
Your Honor, if Mark Secana could go after Mr. Garland as part of number 3, just to clarify the record.
We'll cross that bridge when we get there.
Thank you, Judge.
Mr. Carr.
Good afternoon, Your Honor.
Indeed.
You hanging in there?
Always.
All right, this demur raises both general and special demurs. I'm going to focus on the special demur aspect of it. And when addressing a special demur, some of this argument has been couched in terms of general demurs. Has the state alleged enough to pass a general demur? But I want you to focus on the requirements of the special demur here. The court's got to apply the rule that a defendant who timely demurs is entitled to an indictment perfect in form and substance. And this isn't a horseshoes kind of test. Like close enough is good enough. If the state wants to put people in jeopardy of losing their liberty, at minimum, the indictment must be perfect. And I'm going to start with the topic that's already been touched upon, but which is the indictment's failure to adequately allege the underlying acts of racketeering. As has been discussed.
Can we talk about that perfection real quick? I'm gonna go back to Kimbrough again. To be clear, we do not mean to suggest that a RICO indictment must contain pages and pages of extensive detail about the connection between the enterprise and the pattern of racketeering. Just in that case, they hold that the sparse allegations in that indictment say nothing at all about the nature of the connection are insufficient to enable the defendants to prepare for trial. So yes, they use the word perfection, and then they qualify it immediately.
Yeah, and I would suggest that the pages and pages of detail in this case, Your Honor,
This sucker's 109 pages long.
are anything but.
Okay.
So let's start with these underlying acts of racketeering that the state has to prove in order to establish their case. We've talked about how it's a compound offense, right? You got to prove the RICO, and you got to prove the underlying racketeering acts, which are themselves crimes. And the Supreme Court has said the indictment must clearly set forth the elements of those underlying compound crimes and the facts that support them. This indictment may do that in a few occasions, but the state has repeatedly alluded to and argued there are a variety of other spots in the indictment that satisfy the racketeering act proof that don't contain the elements, that don't contain an adequate application of the facts.
Let me ask you this, are you going to make a differentiation between the predicate acts and the overt acts?
Yes, yeah. I'm specifically at this point in my argument talking about those acts of racketeering we call the predicate acts,
Okay.
right? Those things they have to prove as part of establishing,
That are criminal acts standing on their own,
yeah, that the conspiracy engaged in.
that fit within 5A or 5B.
Right, either the domestic terrorism or 2 other acts of racketeering activity, or the act involving that was discussed extensively before. I'm talking about those.
Okay.
Those are compound crimes that must be adequately alleged, and the courts have told us that. And as Mr. Samuel noted, the indictment doesn't identify any act of racketeering other than to say some undefined number included within the overt acts. There's nowhere in this indictment that says this is a racketeering act.
None of them say predicate act, they all say overt act.
And it says any of these the racketeering acts are included somewhere in these overt acts. It never identifies one racketeering act. We are left to guess. We are left unable to intelligently prepare our defense.
The defendants committed overt acts, this is beginning of part 2, on page 49 of the indictment. The defendants committed overt acts to affect the object of the conspiracy, which include acts of racketeering as described below. And then all 225 say they're overt acts. None of them distinguish themselves as acts of racketeering. That's your argument?
We are left to guess, Your Honor.
Okay.
We are unable to intelligently prepare our defense. as the law requires us to
And I
be
think
able
Ms.
to.
Dixon was saying, some of them set forth in their facts, let's see. I'm gonna go with, on page 84, overt act 152, 153, which is talking about arson. 155 specifically mentions did commit the offense of domestic terrorism. Would that not put the defendant on notice that that's a racketeering act?
Well, then I can talk to you about those.
If it's talking about domestic terrorism, and it actually states domestic terrorism or arson, both of which would qualify as racketeering acts. For purposes of getting to the magic number of 2. Does that not put you guys on notice?
Well, it puts us on notice that they're claiming it's an act of domestic terrorism or arson. It does not put us on notice whether they intend to rely on that or whether there will be proof that that can be one of the acts of racketeering. If you look at this indictment and you listen to the argument of counsel, there is an unlimited possibility of possible racketeering acts. We are left just to go through the indictment and try to figure out which ones they are. Now, as Your Honor points out, where they use the words domestic terrorism, where they use the words arson, that's certainly a key, right?
I'll go back to Mr. Roberta, because I can. He attempted to opt out. It's an overt act. There's not a crime described, a separate, independent. There's no second part of the compound crime there, right? Okay, so you can read that. Does that not put you on notice that that's not a racketeering?
It does to some extent, Your Honor, I agree with you. But for the state to be able to prove to a jury and for a jury to rely on a racketeering act, we've got to know which ones, right? And it's not enough to say that they've adequately alleged some, but they can still prove others, because that's a problem for the special demur. We need to know all the ones that the state would be able to rely on so we could adequately prepare our defense. And so, domestic terrorism, arson, it's alleged in separate counts, 2 and 3 for January 21st, 2023. So that's probably the state's strongest argument, that was adequately alleged, that we're on notice that those are acts of racketeering, right? And there are concerns with that domestic terrorism statute that we addressed in other demurs, so I want to address those here. And then there's the
We're not addressing the constitutionality of arson.
No, Judge, but there is a demur on it, so both of those could be.
I've read it.
But the indictment makes references to domestic terrorism and arson that didn't occur on the number of counts on January 21st, 2023, right? But they don't adequately allege the underlying facts as they apply to the elements of arson in those paragraphs. They mention the words domestic terrorism, they mention the word arson, but remember, the law requires them to allege the elements and the facts that apply to those elements.
And the predicate acts, but not the overt.
Correct. And they haven't done that. Not only do they not mention the elements in regard to the acts on those dates, for instance, the March 5th music festival and the damage to construction equipment that's alleged to have occurred on that day. They don't mention the elements of arson or domestic terrorism in those counts. They don't mention the code section. They don't explain how the facts alleged in those counts satisfy those elements, Your Honor. So while Your Honor's right, saying there is some indication that those could be acts of racketeering, I don't know that. It doesn't meet the requirements that the law imposes. We're left to guess. There is a mention of assault in the indictment. It's mentioned a couple times. Nowhere in the indictment does it mention the code section. Nowhere does it set out the elements of the crime. Nowhere does it explain how those elements, how the facts meet those elements of the crime. It completely fails the test of setting forth the elements and the facts required for compound crimes. If they mentioned assault, the indictment mentions assault, but how can that be enough to put us on notice of what is, that it will be an act of racketeering?
I think that's the Kimbrough case. It's like, okay, this crime could have occurred in 6 different ways. We don't know which one.
I'm, Your Honor, preparing for this argument, I'm reading through the indictment, and I'm just saying, what fanciful argument could be made to this paragraph to claim that it alleges an act of racketeering? Because that's essentially what the state has done. We're left to guess because the indictment doesn't tell us, but the indictment has to tell us. We have to know what the racketeering acts so we can prepare our defense. We shouldn't have to guess. In fact, we don't have to guess because the indictment must be perfect and tell us. Then there's influencing a witness. It never mentions the statute by name. It never cites the code section. It never gives a complete recitation of the necessary elements of the crime or an adequate description of how the facts satisfy those elements. All it does is it mentions some of the language from the statute in various overt acts in the indictment.
Don't forget which official proceeded.
Right. It just talks about some of the elements. So it fails the test. It doesn't set forth all the essential elements. It doesn't set forth how the facts apply to those elements. And then there are, for instance, it makes no mention of the element that it must be done to persuade another person by means of corruption or an attempt to do so, or to engage in misleading conduct towards another person. Makes no mention of that element. Makes no description of how the facts would satisfy that element. Again, it's a passing reference. We are left to guess. Is this just flourish in the indictment? Or is this an act of racketeering? We don't know. It hasn't been identified. And then, of course, there's the official proceeding problem. The statute defines official proceeding. None of that language is in the indictment, nor is there any description of what this official proceeding that is contemplated to keep the documents from appearing. How do we prepare for that, Your Honor? We're just left to guess, but we don't have to guess because we're entitled to a perfect indictment. They talk about obstruction. Ask the state to tell you where the elements of obstruction are shown in the indictment. They're not there. And the state rattled off various paragraphs during their argument earlier that they claim allege facts sufficient to show obstruction. Which ones are those? Are they the only ones? Are there others? How do we know if the indictment doesn't tell us? We are going to prepare our defense by the sketchy notes from an argument here by counsel? No, that's not what the law requires. The law requires it to be in the indictment, and they failed to do so. We can't intelligently prepare our defense. There's some talk of money laundering, but nowhere in this indictment as it stands now are the words money laundering used. The elements aren't set forth. How the facts apply to those elements isn't described. There were counts that originally alleged money laundering, but as you know, those have been dismissed, so they're no longer part of the indictment. It can't inform this inquiry. I mean, I started writing down a list of potential crimes. It's just a pointless exercise, Your Honor, because the state is limited only by the list of predicate crimes and their own creativity to argue to you what's in here. But that's not what the law requires. You gotta allege the elements of those underlying crimes. You gotta allege how the facts apply to those elements. And they repeatedly fail to do that. Now, it's not enough to say, like it might be for a general demur, they did it once, right? They did it for the named counts in the indictment. They did it for the corresponding overt acts that can correspond to the named counts in that date. But that's not what we're addressing here with the special. We need to know every racketeering act that the state would be allowed to try to prove from this indictment. And we don't know that. And then turning to any act involving murder, kidnapping, gambling, arson, robbery, theft, receipt of stolen property, bribery, extortion, obstruction of justice, dealing in narcotic or dangerous drugs, or dealing in securities, so long as those things are a felony. There's nowhere in the indictment that says this is an act involving ... We know they haven't identified any racketeering act specifically, and they certainly haven't identified them as being one of these 5B any other act types. Let's talk about obstruction and murder. What are the elements of obstruction? What are the elements of murder? Where does it show us that in the indictment? It doesn't. What are the facts supporting the existence of those acts as the law requires? We don't know. What are the dates? Who did it? What did they do? We're left to guess. So if we're going to guess, Judge, let's guess. What about the acts described in Part 1 of the indictment? They're explicitly incorporated into Part 2, describing the overt acts, and they say all the overt acts could be acts of racketeering. Could some of those things from Part 1 be the racketeering? Did the state prove at trial to a jury to support a conviction? It talks about Rayshard Brooks. Well, he was shot while pointing a taser at an officer. Is that not an act involving obstruction? Is that a racketeering act that the state can rely on to prove these defendants guilty of RICO conspiracy? It talks about the murder of George Floyd. Are we to assume that the murder of George Floyd is an act involving murder that qualifies as an act of racketeering, supporting a conviction, that we defendants must now be prepared to meet and address at trial? Judge, these examples seem absurd, but they flow directly from the state's theory and argument as to what they have to show in this indictment. Just wrong. The law requires the state to tell us what we're defending against so we can prepare our defense. The state's theory would make it wholly impossible for us to do that. What about acts involving arson? Again, as we talked about, there are some specific numbered counts that address arson on a specific day. The state's arguments, pretty strong, setting aside the other arguments, that they've done what they need to do to identify those acts as acts of racketeering. But as we know, it goes far beyond that. How many of the alleged overt acts involved arson? The indictment doesn't tell us. Which other ones involved arson? How do the facts of those yet unidentified overt acts map onto the elements of arson? We have to guess. It seems that the state's argument is the only limit to the act involving style, overt act, predicate act, is they have to allege some facts somewhere that might arguably support it, without notifying us, without setting out what the elements are, and without explaining what the elements apply to that. That's simply contravened, as Your Honor has pointed out, by Kimbrough and the other cases addressing compound crimes. They focused on other acts involving arson and obstruction today. What are they going to say for the next hearing, for the next motion? What would they allow to be think of next time? How will we know? When will we know? When will the jury know? Will we find out before the jury finds out? The parade of horribles, Your Honor, is endless. That's why we have the law that requires them to identify everything. And, even if we were to concede the aspect that some of these overt acts adequately set out the facts of some crimes, which we don't, and the indictment doesn't, the indictment still fails the test of a special demur in many ways. It fails to identify the facts that support any given racketeering act. It fails to set out the essential evidence, and sometimes it suffers from both problems, as I previously discussed with some of the other potential hypothetical racketeering acts yet unidentified in the indictment. The Supreme Court's clear. the state must provide us this information so that we can prepare a defense. And this indictment makes such preparation impossible. And then from there, we can zoom out beyond. My argument to this point has been focused exclusively on those acts of racketeering, those predicate acts. But we can zoom out from there because the state has to prove more. They have to prove all the elements of the RICO conspiracy itself beyond the underlying acts. And I won't bore you with going through all of the elements of that.
Oh, no, please, by all means,
So the defendant's got to endeavor or conspire to violate subsection B as alleged in the indictment. So they have to be, that requires them to be associated with an enterprise. And so they've got, that enterprise must exist. And that enterprise is at a minimum an association or group of individuals associated in fact.
You said B, there's many Bs here.
Yeah, 16, 14, 4. And I'm referring to the sort of start of count 1 of the code sections they refer to in the indictment. And they must endeavor or conspire for someone in that enterprise to be engaged in a pattern of racketeering activity. That's all the things we've just been talking about. Either the 2 racketeering acts or the 1 act of the domestic terrorism. And the defendant must commit an overt act. Right? That's kind of gets us to our universe of elements that they must prove and frames what the indictment's got to put us on notice of. And Your Honor's honed in right away on one of the big ones. What's the nexus between the overt acts and the conspiracy and enterprise? It's hard to answer that question because we don't know what the enterprise is, Judge.
Isn't the enterprise set out in?
Is it the Defending Atlanta Forests? Is it Network for Strong Communities? Is it one or the other? Is it both? We can't tell.
According to the indictment, defend the Atlanta Forest is a self-identified coalition and enterprise of militant, anarchist, eco-activist, community organizations. That is the enterprise. It's even, because part 1 is the enterprise. A, introduction. B, defend the Atlanta Forest. Then we get into the background of the forest. And C, D, beginning of the defend the enterprise. That's where we get Mr. Floyd and Mr. Brooks. So the indictment is defend the Atlanta Forest.
Right, but what is that enterprise must engage in a pattern of racketeering activity, right? And so it has to have, that enterprise has to be the vehicle through which the conspiracy is committed that has an object or a goal. And that is, what those objects and goals are so broad and ill-defined. It's unintelligible. It's so broad, as Your Honor pointed out, it talks about the black-clad defending Atlanta Forest participant states that the fate of the Kurdish revolutionaries in Kobani and Seri Nave and all these places, it was partially determined by the bloodbath in Damascus and Aleppo. That's one of the objectives of this enterprise inside the conspiracy. We have to be prepared to defend against that. Does that mark one of the outer limits of it? Is there going to be proof of Aleppo? Is there going to be proof of the unidentified person at trial? We don't know who it is by the indictment. We don't know the relevance. But not only does it say too much, it gives such a broad and vague universe of things that are included with this enterprise and conspiracy that it then fails to give enough detail about the ground it does cover. It would require at least another 100 pages to give us enough information to put us on notice of what these things are that they are even talking about in this section. Aleppo, Damascus, masked individuals that are unnamed. And the jury's gonna have the same problem if a case like this is allowed to go to the jury as indicted. How's the jury gonna know what the enterprise is, what the conspiracy is, what the objects are? You know, we've talked about ways that you could limit that beyond the demur, you know, redacting the indictment, striking surplusage. But we're not, as Mr. Senior pointed out, we're not talking about removing a word here or there. We're talking about the need for wholesale change to this indictment that fundamentally changes what it is. It's hard for me to even identify what demurs would remain if we start striking whole swaths of the indictment. Of course, the ones where the state fails to allege the elements of the compound crimes and the facts that apply to it will still be there. But what about the rest? I don't even know. The jury's got to know what's been alleged, right? We need to be able to determine if there's a fatal variance between what's alleged and what's proven. That's why they've got to tell us what these racketeering acts are. Because we have to know, have they alleged it or have they not? We need that to prepare our defense. You know, I go through in my motion that detail, and it seems like Your Honor had a chance to review it. Of all the questions, you know, count one, the part one, defining the enterprise raises, you know, failing to define certain things, failing to identify other things, failing to explain how the enterprise is the subject, define the enterprise,
Well,
how they,
we're talking about Mr. Schwartz's motion.
which I think was my motion, Your Honor, sorry, Mr. Schwartz's motion.
You're
Trying to opt out again, Judge Ernest.
He's co-opting your, I've got, on number 3, I've got Mr. Schwartz's signature on the last page.
He's arguing, we filed a bunch of, I think 3 of the 4 of us did.
Pardon?
3 of the 4 of us filed the same demur.
Okay.
But it
I
was,
just got the one with your signature. I look under your client, I'm gonna find the same motions with your signature.
yeah, I don't think I'm talking out of turn if I say it was just a copy and paste of my motion.
Was it good?
We'll see when I rule.
And so I hate to go through, you know, this 53-page demur, right? I hate to go through every question that this indictment raises. I think Your Honor is
46.
Okay. It has reviewed it and sees all the questions this indictment raises. It doesn't describe the alleged criminal purpose of defendant Forrest. It doesn't describe how individuals joined the conspiracy. It fails to describe the acts of racketeering activity. And the list goes on and on about all these vague concepts that are introduced but not tied in, not given a nexus to what we're dealing with here. All right, and then turning to part 2, which the overt acts. You know, the indictment sort of breaks these down into various categories. Payments, online, the indictment. The demur breaks these down into payments, online postings, the January 21st protest, the March 23rd event, the flyers in Chupa Soseto's neighborhood, the forest occupation, property destruction, and uncategorized.
You're on part 2?
Yeah, the indictment.
Oh, the indictment.
Yeah.
I thought part 2 of the demur.
Well, which is titled, you know, part 2.
Online postings.
Yeah. Roman numeral 2. Number 2 within Roman numeral 2. So you'd have to back up to get to Roman numeral 2. Payments would be 1. Online postings is 2, and above that is Roman numeral 2, describing Roman numeral 2 of the indictment, which would be overt acts. Am I making sense yet, Judge?
No.
Okay. The indictment alleges overt acts as we've talked about. And part 2 of the RICO count, pages 49 through 100, alleges 225 overt acts, right? And so those acts raise all kinds of special demur problems. So I just want to turn
225 of them, I imagine.
greater than 225 problems for the 225 alleged acts. And those are the ones that I just described, payments, online postings, and so on. They kind of break out into categories, even though they're not explicitly done that way in the indictment.
I think both sides have categorized them.
Yeah. And so a variety of questions keep rearing their head with these overt acts. What's the nexus between these acts, either racketeering or overt, and the alleged enterprise and conspiracy? How are the alleged acts connected to the enterprise? How did the alleged acts further the purposes of the conspiracy? How did the defendants not named in the acts conspire or endeavor to further them? For example, when you look at the January 21st protest, and so it's quote-unquote night of rage.
Now, at some point, there's a difference between a proper indictment and adequate proof of trial. We can agree on that, right?
Absolutely.
They don't have to prove their case in the indictment.
Absolutely.
Okay, they allege the nexus, but then they're gonna have to prove that nexus, right? But you're just saying the allegation needs a little better, a little more work.
Yeah, I'm not sure they allege the nexus, Your Honor, in
You're
these.
saying they have to.
They have to, that's right. And that requires answering some of these questions that we raised. Maybe not every question, Your Honor, right? It's kind of one of those things.
There's a lot of questions.
There's a lot of questions, but you know, you may not have to get all of them, but you gotta get some of them to put us on notice. I raise every question that can be asked. Not every question has to be answered, but somewhere, some fundamental aspect, some of those questions have to be answered to put us on notice. And I agree, they could answer some, but not all of them, and they meet their obligation. They haven't answered any of them, Judge. It's January 21st, night of rage. How did an individual on a different day that wasn't there conspire, endeavor to have that happen? Well, we don't know. We just have to guess. And so, turning to the overt acts alleged, the category of payments, there's all kinds of these alleged payments that mostly allege Savannah Patterson, Marlon Katz, and Adele McLean reimbursed others for various items with the funds from the Network for Strong Communities.
And given that the money laundering charges have gone by the wayside.
Is this a racketeering act? We don't know, Judge. We don't have to guess, because the indictment has to tell us, and this indictment doesn't. And it talks about all kinds of items that were paid for. Forest monitoring equipment, you saw it in the demur. Forest monitoring tools, food, gloves, tarps, power packs, deep May tuition, glue, bins, generator, restroom support, tools. I mean, the list goes on and on and on and on and on. How did any of those things further the conspiracy? What's the nexus between the tool and the conspiracy? Between a power bank and the conspiracy? I don't know. It fails to describe how each item was used to further the conspiracy. It fails to describe how the transfer of funds was made. It fails to describe how or if the act was connected to the enterprise, how they furthered the RICO conspiracy. Like I said, maybe you don't have to answer every question, but you gotta answer some. We've got to know what we're facing. And of course, as previously been identified, and who are the unidentified co-conspirators whose identities are unknown to the grand jury? Not only do we not know if it was the three named defendants. It could have been any number of people that we don't know that did these. How do we defend it against that, Judge? We can't. Then we turn to the online postings. They generally allege that Cox, Patterson, and McLean, and then again other unindicted co-conspirators, posted to scenes.noblogs.org to threaten others. We don't know how they posted the post. We don't know the content of the post. We don't know how it furthered the conspiracy. We don't know who's the target of the threats. We don't know how these posts demonstrate that they intended to cause and induce the alleged target of the threat to withhold record, documents, and testimony in official proceedings. Is this a witness influencing act, predicate act, act of racketeering? I mean, it mentions some of the language from the statute, but it doesn't meet the requirements of setting out all the elements and how the facts apply to them. What are the documents that they're trying to get them to withhold? What's the official proceeding? How's it connected to the enterprise? How did it further the RICO conspiracy? I mean, these questions repeat over and over and over again in this indictment. This indictment raises many more questions than information it provides to us on how to prepare a defense. And then we turn to the quote-unquote night of rage on January 21st, 2023. What's the night of rage, Judge? Do you know what it is after reading the indictment? I don't. How did these actors join the night of rage? It doesn't, what was the arson that was committed? How was it committed? Again, what were the elements? How did the facts apply to the elements of arson? Is this an act of racketeering? Or is it not? Is it just an overt act?
Does it not appear from the indictment that someone took a hammer to try and break into a building and set it on fire? Now, where the night of rage moniker came from, that's a whole other issue.
I would submit that it doesn't, Your Honor. Let's go to Act 152.
I'm good, man. Yes, 152.
And are you referring to 156? Did possess a hammer while attempting to break into 191 Peachtree Street?
Well, 155, possess an accelerant while attempting to break into 191. Possess a hammer while trying to break into. Now, I don't know how spray paint has anything to do with arson. That's 157.
How is that connected to the night of rage? We don't know. What the night of rage is, we don't know. We don't know what the property damage might be. Maybe it's breaking a window. Say they had a hammer. And then,
As I said, there's perfect, and then there's perfect.
and how is this domestic terrorism, Judge? How is this described?
That's a different motion.
Well, I mean, it says it right there
I know.
in 155. Commit the offense of domestic terrorism. How do these facts establish the elements of domestic terrorism? We don't, they don't, Your Honor. The allegations of these facts is wholly insufficient. Had a gas can, had a hammer, some spray paint, attempted to break in. And that's supposed to satisfy the elements of domestic terrorism? I don't think so. The indictment doesn't meet the requirements of adequately alleging these predicate underlying crimes that's required when they allege a compound crime like RICO. that a racketeering act that we have to be prepared to meet, Judge? It might be, but that's not enough for me to say it might be, for you to say it might be, for them to argue, oh, it is. The indictment has to tell us. They don't get to tell us. The indictment has to tell us. And these questions repeat over and over and over again. Like I said, it doesn't have to have every fact we want to know, but it's got to give us enough to know how's this domestic terrorism, right? And let's turn to the March 5th event. This is the music festival and the damage to the construction equipment. Many questions arise here. Where did the criminal trespass occur? How were the elements of criminal trespass committed? How did the criminal trespass further the occupation of the DeKalb forest? How was it connected to the enterprise? Remember, we don't have to answer everyone, we got to answer some of these. I mean, we don't even know where the trespass was supposed to have occurred. Was it where the music festival was? Was it where the construction equipment was? Was it both? These are areas where the ownership and ability to exclude people from the land is not clear based on an indictment. And we know that there are areas that the city had under control and areas that the city didn't have under control. Which one was it? How do we know? We can't. How was the mob organized? How did the mob cause property damage? Where did the mob attempt to cause property damage? These are things that are not in the indictment that we don't know. They're set out in detail in the demur, Judge, all the different questions that can be asked. But it also talks about domestic terrorism, talks about arson. We need to know the elements. We need to know how the facts apply to those, and the indictment doesn't do that for us. How it was connected to the enterprise and how it furthered it. Then we've got the flyers and troopers to say those neighborhood. How are those connected to the enterprise? How did they further the conspiracy? There's the forest occupation. Where did it occur? How is it connected to the enterprise? How is it connected to the conspiracy?
Are you looking for GPS coordinates, sir?
Well, I mean, when it comes to the trespass, when it comes to the forest occupation, we need some definition, some description of where they were allowed to be and where they weren't. And this indictment doesn't point us to that. And the questions are the same in the group of the property destruction group of acts. For instance, how does the indictment tell us that by vandalizing a Brassfield and Gorey office building in Cobb County, they demonstrated that they had the intent to cause and induce Brassfield Gorey officials to withhold record documents and testimony in official proceeding? What's the nexus between those two things? What's the connection? We're left to guess. What's the official proceeding? And how do those acts connect to an effort to get them to withhold documents? For each group of acts, the same questions can be asked over and over again because they remain unanswered. In the end, Judge, we're left with an indictment that doesn't tell us what we need to meet. We're left to guess. And that's a result prohibited by Georgia law that calls for a granting of a special demur.
Okay. Before you jump up, I'm gonna take 7 to 10 minutes, and then we'll be back, and who's going for the state?
So this one is fixing, is gonna continue on this one.
Okay. Take 10, y'all.
What do you know?
Mr. Garland, if it's a fair deduction that an overt act that clearly doesn't allege a criminal offense couldn't be a predicate to RICO. And that's not what the state said at some point today, but then, just based on that comment, I want to make sure we're on the same page. The state has conceded that a predicate act must be a criminal act?
No.
No, okay. Good. Thank you.
Okay.
Judge, first off, let me apologize if I just spoke.
No, I'm curious to hear this now.
Okay.
So a predicate act doesn't have to be a criminal act?
No, not one of the racketeering activities. And let me get on case, Judge, because we talked.
And that's, you're basing that on 5B?
Yes, and the case, well, particularly on Dorsey, this Georgia Supreme Court case that specifically held that. And I know I get to reading too fast at times. I'll try to make sure and let me just read a little bit more and not try to go so fast. Dorsey challenges, oh, excuse me, this is the Dorsey v. State case.
Right, no, I remember that.
Okay, all right.
That Mr. Samuels vehemently disagrees with, but is still good law.
It's still good law. And just so that we understand just why Mr. Samuel's so vehemently, and I
Because it's
understand.
not good for his client.
Well, and, I mean, I
Or for
understand.
Sheriff Dorsey.
Definitely, definitely. But Judge, just to give it some perspective on why my answer to that is no. Dorsey challenged category 5, which I talked to you before, predicate offenses. Each concerning an act involving murder. The basis for his challenge is that a preparatory act which standing alone may not be criminal cannot constitute a RICO predicate. And then it goes on to say it belies that claim. And then it goes on to explain that the under subsection B, 5, so it's, we know what I'm talking about. It does not have to be a criminal offense. Okay, all right, so that's the answer to that. As far as the argument raised by Mr. Garland, I'm going to.
But if it is a criminal act,
Yes,
then you have to delineate and put forth all of the elements of that?
if it is a criminal act, you have to put forth all of the elements, all of the essential allegations and elements of the offense within the indictment, yes, sir. Not within that one
Even
count.
if it's, not if it's one of the 225 overt acts?
It does not have, okay, so for a predicate act, yes, somewhere in that indictment,
If the predicate act
Yes.
is also a criminal act,
yes,
then if it is enumerated within the RICO count, it meets the elements of the offense.
the state's contention is that as long as the indictment, read in the whole, sets out all of the elements of that underlying offense.
That's exactly what Kimbrough said you can't do.
That Kimber was not a compound felony case, I don't believe, Judge. I don't believe, because that Sanders,
It was a RICO case that dealt
It was a
with
B.
drugs.
but it was not a conspiracy to commit RICO. And technically, a conspiracy to commit RICO is like a doubly compounded case. And I mean, to be quite frank, I haven't read the Kimbrough case since September last year in great detail, but I have read the Sanders case, which is in 2022, and it specifically states that in compounded cases, or twice compounded cases, like conspiracy to commit RICO,
Well, I think Kimbrough's even worse for you because it's not compound. Compound, you gotta do it, but Kimbrough says you gotta do it in a non-compound case because in Kimbrough, because I read the Court of Appeals one first, read what they did wrong, and then go see what the Court of Appeals tells them they did wrong. And in the case at the Court of Appeals level, they said, hey, see as follows below. Not unlike your page, part 2 on page 49. The defendant committed overt acts to affect the object of the conspiracy, which include acts of racketeering activity as described. See below.
Yes, sir.
Okay. Now, this is all in one count. The problem with Kimbrough was there was count 1 and then they enumerated the other counts. You just enumerate them as separate overt acts.
Yes.
But they still wanted, you couldn't read it, specifically they said it's not a read as whole kind of a thing.
I don't know, Judge, quite frankly. I mean, I would have to really, compare, and we can do that, but what I know is.
We have held that an indictment not only must state the essential elements of the offense charged,
Yes.
but it also must allege the underlying facts with enough detail to sufficiently apprise the defendant of what he must be prepared to meet.
Yes.
Okay, and that's the English case also as well.
Yes.
And we also kind of get a little upset that the indictment says nothing more, however, about the nature of the alleged connection between the enterprise and the pattern of racketeering. These folks are asking for greater detail about the connection by their specialty murders. And this is Kimbrough on page 880. Go ahead.
So, Judge, I don't know where
Where we are was, not every predicate act has to be a criminal
Yes.
endorsing.
Yes. And.
But
and
if it is a criminal act,
if it is alleged under A, yes, sir. Or domestic terrorism, yes.
if it's a criminal act,
Yes.
because it can also be a criminal act, it can be a criminal act under
Yes.
B.
Yes.
If it's a criminal act, you have to set forth the elements.
Within the indictment, yes, sir. Or facts, what is this, let me quote it. The state's position is that,
You're at Sanders?
yes, sir,
All right.
on page 200. And
In order to satisfy due process, when an indictment charges a compound felony, such as felony murder, but here it's conspiracy to commit
here we go.
the count charging the compound offense, which here's count 1,
Yes, sir.
and the listing of overt acts, I inserted that, but the count charging compound offense must contain the essential elements of the predicate offense, or the indictment must contain a separate count charging the predicate offense completely. That didn't happen here. It did as far as the arson and domestic terrorism.
Yes, sir.
But the rest of the stuff, not so much.
Right.
Or the indictment must elsewhere allege facts showing how the compound offense was committed. Okay?
Yes.
So, Mr. Garland was up here saying, show me my essential elements. When you say, where there's one count where it's just, this is domestic terrorism, I'm gonna hope that you will, admit that that's a predicate act.
Yes.
Okay, so he wants to know where are the essential elements of that. Let's count.
Which paragraph, Judge? Computer's on this slide.
152.
I know that one, Judge.
To join the night of rage in Atlanta and cause arson and property damage and thereby commit the offense of domestic terrorism.
Yes. So my answer to the question of where are my essential elements is count 2 of the indictment, which is allowed under Sanders with that, you said or. So it's either in count 1 or alleges another count in the indictment, count 2, or sufficient facts to show how the compound offense was created. We're under 2 for that.
So you're relying on count 2 for that?
Yes, to establish the, yes, sir, for the domestic terrorism.
Oh, and then we're gonna get to the demur on that count later.
Yes, sir.
Okay,
Okay, I'm,
but that was just one example of the domestic terrorism. There are other predicate acts in here, criminal acts.
yes,
You've alleged an aggravated assault
yes,
by giving someone information.
we argue that, yes, sir.
Yeah, okay. Essential elements.
And the elements of aggravated assault are the fact that an assault was committed and it was done with a deadly weapon. And of course, under Georgia law, you don't have to plead or allege the party to a crime, whether it's aiding and abetting or party to it, you know, we don't have to allege that. And so whether or not there are facts sufficient in the indictment to establish that, aggravated assault could be, first of all, you would have to say, could aggravated assault be holding a gun to somebody's head, and specifically naming that person, saying it was an aggravated assault? State says yes.
Slow down.
I'm sorry, I do that when I get, sorry. And if then providing information to that person, again, that is our argument, that is, anyway, that's our argument. As to that one incident, but, with regards to the, other parts, it is that there you have acts involving, and really, Judge, and I mean, you had, excuse me, I made an extensive argument before the court, which went through why or how we believe there's certain predicate acts, racketeering activities, and predicate acts that are criminal offenses under A have been alleged. But their entire argument, really, with regard to the predicate acts being alleged with sufficient particularity, it really ignores B and the Dorsey case.
Well, I think their initial argument was, tell us which ones are predicate just to start with.
Okay, let me get to
How about just that? Because you say there are predicate acts or acts of racketeering activity, which would be the predicate acts, as described below. But it is not your contention that all 225 of
No.
these are predicate acts,
No, sir, it is not.
and none of them are individually identified as predicate acts. So how is that not leaving it up to the defense to figure out which predicate acts they need to defend against? Because let's say there's only 5 of them, they can knock out 3, they win, right?
Knock out 4.
Well, you gotta have 2 predicate acts. If you only gotta get 3 to win, okay? Mr. Samuels?
I did mention that I'm not good at math, could y'all quit?
I am mathematically correct, am I not, Mr. Samuels?
We win if we knock out 4.
You knock out 3.
There's still 2 left in yours.
If there's only 4 and you knock out 3, there's only 1 left.
He did say 5, didn't he?
So,
Yes, sir.
if they don't know how many predicate acts they have to defend against, how is that not leading them to guess? Because they're gonna marshal their energies, because if somebody bought food, and that's an overt act, they might not give a fat baby's behind about fighting that one. They may say, yeah, my guy bought food. Okay, so how are they not left to guess which ones are and which ones aren't? Because some of them are crimes, and you're saying, well, it's pretty obvious that this is a crime. But on the other hand, you're now telling the court, well, predicate acts don't even have to be crimes.
That's true.
Under Dorsey, agreed.
Yes, sir.
How are they supposed to know which is which?
Based on the contents of the indictment and the allegations, and the statute, and how it's defined. And in fact.
And I think if you would have said, hey, this is a predicate act under 5B, this is a predicate under 5A, Roman numeral, whatever, if you had identified that, instead of leaving it up to them to guess, they would know how many out of 225 are the predicate acts that they've got to marshal their resources.
I do not disagree that if we had delineated, that it would make it easier and better for the defense
How about
and
we,
for
how about we
the.
call it perfect?
Well, perfect in the sense that it is not actually required as the state's position. Because they offer no authority whatsoever for the position that the state must delineate or with nomenclature. So there's, and I did look, maybe there's a case out there. If so, I'd like to see it. I have not been able to find it. But there is no authority that the state is aware of or that I have seen cited by the defense that says that to be a sufficient allegation in the indictment, that a RICO count charge must delineate these are predicate acts. And judge, in that context, there is a case, Brown v. Friedman, 222 Georgia Appeal, Georgia App 213 on page. I'm sorry.
How about just the fact that an indictment has to enable the defendants to prepare for trial? And if they don't know what predicate acts that make up one of the three counts, if they don't know which acts are going to get their clients in trouble for that one count, how are they able to prepare? They've got to guess how many out of 225. Because if, like I said, if there's 5, then they got to knock out 4. If there's 200, then they got to knock out 199. But they're left to guess.
And Judge, I would go back and I'd come back to Brown, but give me 2 seconds to find cases I have cited.
Especially where a predicate act doesn't have to be a criminal act. That makes it even harder to show with just there are no elements to put in there. You know, what's the element of a criminal act? Well, it's not a criminal act, it's a predicate act.
Judge, and I do not have this, the entirety of this case in front of me. However, I think this case was cited by the defense. 303 Georgia App 183 at 186.
Hold on a second. 303 Georgia Ave.
Yes, sir. 183 at 186. And in candor, I do not have the entire case before me, but I have a quote from that
State
case.
v. Bear,
Yes, sir.
2010.
On page 186.
Well, you don't like the first sentence of
No, sir.
186,
I do not.
which is the state's argument ignores important facts.
Yes. That's never pleasant for a prosecutor to hear.
Right. The test for determining the sufficiency of the indictment, is that the language you want me to read?
Yes, sir.
The test for determining the sufficiency of an indictment or accusation is not whether the charging instrument could have been made more definite or certain. Agreed, it is perfect in English code. Or for that matter, perfect, but whether it contains the elements of the offense intended to be charged and sufficiently appraises the defendant of what she must be prepared to meet. And in case any other proceedings are taken against double jeopardy. So this is the same language we've seen. Yes, this is.
Yes, sir, Judge. I'm trying to find the portion of.
And then it says, thus, if the accused can admit to all of the indictment or accusation or citation charges still be innocent, the indictment or accusation is defective. That's as to a general demur.
Yes. Yes,
The
sir.
argument Mr. Samuel's partner was making was special demurs, saying, hey, where is it? Because it's general and special demurs to count 1, insufficiency. I don't know which of these, he's saying, yeah, I mean, he's admitting some of these have criminal elements to them, but they don't satisfy the requirements because they don't have the actual elements in them.
Yes, sir.
And I don't know whether it's a predicate act or not. It's a criminal act, I don't want my guy pleading to that. But is it predicate or is it just a benign overt?
So, Judge, and I'm struggling, but to locate where in that particular case it says this, but I will assert in court that there is established Georgia case law that says in assessing the sufficiency of the indictment, that you read the indictment and the allegations contained in the indictment along with the criminal statutes. And so, for example, and this goes into...
Although recitation of the statute may, in certain cases, be sufficient, though not may be a sufficient, though not desirable, method of apprising a defendant of the charges arising against him. Recitation of portions of the statute is not sufficient if, reading the accusation together with the statute, a defendant is unable to determine which of his acts are alleged to be criminal in nature.
So that is one of the cases. So that
Insert the word predicate act for criminal in nature. Because you know there's a requirement of so many predicate acts, right? 2 predicate acts or 1 domestic terrorism, right?
yes, sir.
Okay. So if a defendant is unable to determine which of his acts are predicate acts, or alleged to be predicate acts,
Yes, sir.
is that not problematic?
I think it is not I'm just gonna say it. I think it is not the best way. I think that it would be more clear, but I do not think that it is fatal to not identify them. And let me give you Brown, and I do have a copy of that whole case, Judge. Brown v. Friedman, it's a civil case, and so I understand, but it's a RICO case, and therefore has,
You know,
sorry,
not for nothing.
yes, sir.
You know how I read all their motions? I would have loved to have read some responses. And as Mr. Samuel pointed out, I have nothing to read from the state of this. Nothing.
Yes.
And it's been 2 years.
Yes, sir.
Because I kind of pride myself on trying to come prepared.
Yes, sir.
So what's your Brown site?
The Brown site, Judge, is .222 Georgia App 213, and I'm gonna.
She goes. All of these cases cited by both sides all have big yellow squares, big yellow triangles next to them.
I will tell you that there was not a single one that I'm citing that you don't look, because there's it's all distinguishing, and so it's,
And it's on other grounds.
yes, it's,
Well, again, all right, I'm on it.
so Judge 217, and, essentially, the reason I am directing the court to this is this was not particularly the primary issue in the case. However, in that case,
It's a summary judgment case.
it is a summary judgment case. And Brown contends that the trial court erred in granting the summary judgment to the defendant Friedman on the RICO claim. A RICO violation with a code section, and any subsequent recovery through another code section requires that Brown show an injury pattern of racketeering activity. A pattern requires at least 2 interrelated predicate offenses. Here's the important part. In her complaint, Brown does not expressly allege which of the acts she recites in her narrative of events constitute predicate criminal acts for RICO purposes. In her brief to this court and in her response to Friedman's motion below, she alleges theft by conversion, theft by deception, and mail fraud, which constitute RICO predicate acts. although she does not specify all the acts which she alleges constitute these crimes, at this point, she is not required to do so. Freeman can ask for a more definite statement. So,
Freeman's not going to prison if he loses.
I said that it was a civil case right off the bat.
That's-
And so, but my point is, Judge, that the only case law,
Let me rephrase it. Freeman didn't face prison.
that's true, that's
Because
correct.
last time I checked, there was no mandatory sentence on it.
Correct. Correct. And it's not mandatory on DT. I was about to say. So,
The agreement of the state. What, on domestic terrorism?
You know, on racketeering it's 5 to 20, but the 5 can be probated.
Right.
Right.
I was wondering.
Yeah, it's not mandatory prison time, but mandatory. Splitting hairs, it's not relevant.
There's no mandatory incarceration for, potential mandatory incarceration for Mr. Freeman.
That's true, Judge. I'm not
So
disputing
it's-
that. It started at the very beginning, said this is a civil case. However, there is no, again,
And at this point, she is not required to do so.
they're talking about.
Freeman may move for a more definite statement. We don't have that in the civil arena. What we have is a general and a special demur, and they are doing that. But you're not allowed to amend your complaint. You can't amend your indictment. Which is, so I think that's just easily distinguished away. So I'm gonna close that window.
Yes, sir. Close that window. It was, and it goes back to, I looked hard, there's no case law that requires that they be delineated. I understand what your point
There is case law that says they gotta know what they're defending.
Yes, and.
Lots of.
And the state's position is that when you read the statute, which is a limited number of excuse me, when these lawyers or their clients read the statutes, which defines specifically what racketeering activity is, and it defines which racketeering activity, which criminal offenses can be racketeering offenses, and then it defines in subsection B a limited, a much narrower limitation of which criminal offenses, acts, or threats involving those criminal offenses can be the basis of racketeering activity. And that, from that, when the state alleges that he participated in, and I don't have one in front of me because I just turned the page, but when there's an allegation in a paragraph in those 225 predicate, overt acts, and it says he did X, Y, and Z, facilitating an arson, and the word arson is used, I think any rational person or reasonable person would know that that is an activity or an action or an allegation of an act or threat involving arson. So, yes, I think.
Okay, so then it's a criminal act, right?
It would be under B, so no, sir. We don't have to allege an arson. We have to allege under B. We have to allege that they committed an act or a threat involving arson. And so when we say, let me find one, Judge, if you don't mind. Will you find one of the paragraphs that mention arson, but don't charge arson for me, please? And Mr. Fowler's gonna give me an example. Actually, 194, hang on, I may have some. Okay. This is an example, Judge. 24 times on 194 through 217 alleges that on or about March 5th, 2023, insert name, 24 of the different defendants, did join an organized mob and succeed in overwhelming the police force, thereby aiding and abetting in the offense of arson. And then it's with purpose. So, I mean, with the attempt to occupy and prevent. Any person can read that and say.
Is this the arson that occurred back on January 21st?
No, it's on March 5th that he did join the organized mob to attempt. So reading it says, look, these folks got together, they organized a mob, they succeeded in overwhelming police and aided and abetted in an arson. And that was on March 5th.
Because
That-
the arson that's alleged in the indictment is from January.
January 21st, and that is alleged in a different, there are facts, the facts supporting the overt acts and the racketeering activity is alleged for that particular arson.
The, in abetting the offense of arson. How are they supposed to know which act of arson they're defending against?
So I don't, first of all, I don't think that's where we get into, I don't think you have to allege that. It's just like that Dorsey case. Well, while I understand people may want us to have to, we don't.
Is aiding and abetting arson not a crime?
Aiding and abetting arson is a crime, but they are not charged with aiding and abetting an arson. And
But it's
they're
a predicate act that is a crime.
we are not,
Yes.
I mean, it can technically fall under aid, but that's not how we're charging it. And
We
if,
don't know because you didn't say.
I think it alleges the facts necessary to put them on notice that those are actions involving arson. And there are others,
What arson is gonna be what they're gonna ask? Which arson did they aid and abet?
the one on
Because the only one that's listed is the one on the 21st.
that's the only separate offense of arson. But it is not the only arson that's mentioned because it specifically says on March 5th, they aided and abetted an arson. They're not separately charged with that, but
Can you show me an overt act in the list of 225 that just talks about arson? Because I'm looking, like I said,
Maybe.
205, from 194 on.
I don't know if it uses the word arson, Judge. 2 seconds. Is arson used elsewhere in the overt acts? Will you check for me?
Well, how are they not guessing that? I mean, I'm not trying to be flip, I'm genuinely curious.
So Judge, to the ones I'm talking about, the 24 that I'm speaking of,
Starting at 194.
starting at 194.
Okay.
I will mention, if we look at Dorsey, I understand the court's questioning and point with regard to that, but Dorsey did reject this idea. So in Dorsey, the defendant was charged with acts involving murder. Murder is also an A offense, under where you're actually charging a predicate act that is a criminal offense. Under A, you must set out all of the elements because you're saying they committed the crime.
Hold on a second. I'm looking at page 541, Dorsey.
Yes, sir.
Dorsey challenges category 5 predicate offenses, each concerning act involving. Okay, here's the difference though. I don't think I've heard them say, Mr. Bell, you correct me if I'm wrong. They're not arguing that that act can't be a predicate act. They're just saying it's.
I understand, yes.
He's not challenging that that can't be a predicate act.
Not at this point, no, sir.
Mr. Garland, is that correct?
We need to know.
He's just saying we need to know.
And if it is, the indictment's gotta tell us, not the state. The indictment's gotta satisfy the requirements of the elements and the facts that apply to
Well,
it.
and what she's saying is, just like this said, an act involving murder, the state has said an act involving arson and terrorism, and domestic terrorism.
And Your Honor, I could wait till the state's done, but I do have a response to the Dorsey case.
Go ahead. Go ahead.
So, Judge, the other thing you had asked me for other references to arson, another reference to arson is where one of the, and let me not be vague,
Please don't. Well, because I think that's what most of these folks here are accusing you of right now.
So the word arson is also mentioned in paragraph 130, which is one of the publishing a post on scenesnoblogs.org, claiming for responsibility for an arson and using that as a way of threatening.
So, them being in the forest and joining a mob in March is aiding and abetting an arson that occurred in Portland on January 1st?
No, sir, I am confused as to what your question was. I thought you were asking me to tell you where else in the 225.
How are they supposed to know which arson you're talking about? Because the murders in Dorsey, there was but one murder. There was but one murder. So an act, a predicate act involving murder. Everybody knew which murder they were talking about. We don't know, they don't know what arson you're talking about.
The allegation is that they attempted the arson on March 5th. So and did acts to attempt.
Dorsey was charged with a murder.
Yes, sir.
One body,
Yes.
okay? Some of these defendants are charged with one arson that occurred on January 21st?
Yes.
Okay, and in March, they're accused of aiding and abetting arson.
Well, there's also accounts in the 225 that pertain to.
Those aren't counts.
Sorry, there are also paragraphs in the 225 listing overt acts, which include predicate acts.
Is there even an arson that is alleged on March 5th?
There's not a separate crime of arson on March 5th.
But yet they, on March 5th, they aided and abetted them.
Yes, because the underlying arson, there is no venue for to bring in an indictment in Fulton County. We could not bring that as a separate account because this court lacks, and this county lacks venue over it as an individual or a separate offense. So we couldn't include it as a separate count.
Okay, because the fire was in DeKalb.
Yes, sir. But our position.
That might be information that they would have wanted to know about. This thing got burned up in this place. You may be 100% correct. Can't bring it as a separate account because it didn't happen here.
Yes, sir.
But it puts them on notice as to what they've got to defend against.
And Judge, the only thing that I can tell you is that I'm not going to sit here and argue that, that more detail could be provided, that it couldn't be better or more perfect, if you will. What the state's position to the court is that there is no legal authority and there is no case law or precedent or persuasive case law that supports the position that us failing to identify which overt acts that are also included directly and specifically in our indictment as including racketeering activity, that by failing to delineate which are overt acts and predicate acts, there's no case law or authority that says that that is a demurrable flaw in the indictment. That's my
Sounds like
position.
no matter which rule there's about to be case law.
Possible.
One of you is going to take me across the street.
Completely possible.
Before or after trial?
So that is my position, Judge, and I do understand what the court is saying. I understand their argument. Why are you looking at me like that?
Just, the brow is furrowed, that's all.
Okay. I didn't know if that had said something that you were questioning. So with regard to that issue about delineation and articulation, of which I think I've answered that.
Who's
Go.
alarm on?
That was me.
$50, charity of your choice, you're sending their receipt.
Sure. Supposed to take my son to climbing.
all these people have climbing gear. Gallows humor, y'all, sorry. Go ahead.
Thank you, Judge. I just need to respond to a few more things. Let me make sure.
Before he has to go stone something.
Excuse me, I would never go to Stone Summit.
Too much. I've already sent that to you. Okay, so there was arguments in the defense made that, for example, anything in claim in part one could be a predicate act, and Judge, I just quickly and bluntly, it just doesn't that lacks basis, because it's clearly delineated that it says, and the following are going to be, or alleged to be overt acts in furtherance of the conspiracy, and some include,
Oh, you're addressing their concern about how do they know they're gonna have to defend against stuff coming in out of part one?
Yes, I'm sorry if I didn't say that. Well, but there was a lot of things said, and I'm trying to make sure I hit them without blowing. So I'm trying to begin back at the beginning of their argument, and that is where they started essentially. And the point is that it's very clear and is delineated in the indictment when the allegations regarding overt acts, which include predicate acts of racketeering activity, begins, and that is the language that has been stated up, but it's
Okay,
part two.
let me read you the chunk of language before part one.
Before part one?
Yep.
Yes, sir.
The end of, you got count one,
Yes.
racketeering. Lists all 61 folk. For said accused individually as persons concerned in the commission of a crime and together with unindicted co-conspirators in the state of Georgia and the county of Fulton on or between May 25th, 2020 and August 25th, 2023, while associated with an enterprise, did unlawfully conspire and endeavor to conduct and participate in directly and indirectly such enterprise through a pattern of racketeering activity in violation of 1614(4)B, as more particularly described below and incorporated by reference as if fully and set forth herein, contrary to the laws of the state of Georgia, thereof. Part one, the enterprise.
Yes, sir.
So all the facts in the enterprise are incorporated into count one. You stand before me saying, hey, Judge, we're just talking about those 225 acts. I'll take you at your word. They can't. They gotta take the indictment as written.
Which says introduction, the enterprise, and one of the elements we
It
must
says
prove.
part one, the enterprise.
And then it gives an.
A, introduction.
Yes,
B, defend the Atlanta forest.
yes.
Anarchy background of defending the forest. Beginnings of defending the forest. Shadowbox Studios, Cobb County, land swap. These all have facts in there,
Facts, yes, sir.
okay? That defend the Atlanta forest overview. Defend the Atlanta forest funding. Now, and we run into the whole money laundering issue. Communication, talking about signal, telegram. Entity amount total $48,000. Occupation insight. There are facts, and yes, obviously we're going back to the how many centuries. That's a little different than, hey, propaganda and recruitment. They're going to have to defend against this.
Defend against it in the context of an overt
In
act.
the context of, is there an enterprise? Did they use these things to build an enterprise? Is there indeed an enterprise?
Then yes, Judge, any and all evidence we have at our disposal to establish and to show that this group of individuals were associated in fact and that they had a common purpose to commit racketeering activities any admissible evidence to prove that, absolutely, they should be prepared to defend against it. If it's not admissible, the court will say that, they don't have to defend against it. But as far as whether there was an enterprise, 100 for every single fact that we can use to establish the association of this group of people, how they were funded, how they recruited, sure, we have to.
But
I mean,
none
they're
of that,
arguing.
none of that,
Yes, Judge, it is in there, recruitment, well, let me let you finish your sentence, excuse me.
I'm now into your 225.
Well, now that's a separate issue, because all of that goes to the enterprise. It affirmatively avers that, and I think I've said this, but I'll say it again, defendant in the Atlanta Forest is a self-identified coalition and enterprise, blah, 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 and that organization coordinates, advertises, conducts direct action designed to prevent the construction of those things and provoke anarchist ideas. This self-proclaimed direct action has included, and then it lists the various things, vandalization of private property, arson, destruction of property, tax on law enforcement. Anyway, so the point is, while I'm there, that is the nexus. It affirmatively argues the nexus. And then we get to all of the other things that are alleged about the description, because we must prove and allege enough detail to establish the enterprise. And Mr. Fowler's already talked about why the history and things of that nature are.
So are they gonna have to defend against masked folks making statements? That was raised by the defense.
If it's admissible, yes, and the state is going to say that some of those things are admissible, yes, sir. If a co-conspirator that we can establish, our co-conspirator produces propaganda that talks about different things about this conspiracy, and I know people throughout the confrontation clause, in no way is it testimonial, in no way. So if we can establish, because it's not testimonial, because it's not made, this is well before any type of arrest or prosecution, so there was no possibility that it was gathered for the purposes of litigation. If we can meet the elements of admissibility, that's the reality of it. But that's true of any situation, Judge. The state is going to use any and all fact that the state believes and can show furthers its proof of various facts in the case. And if those are admissible, yes, they should be. Now they're going to argue that they're not admissible. We will argue that they are, and the court will decide what comes in the end. But yes, any and every piece of evidence we have that establishes, well, for one thing, when it began, when the conspiracy started, when they started making plans, when they began the occupation of the forest, all of those things for the very reason of what we've been arguing about today, for one thing. It all becomes relevant. So that is part one. And to go back to how they know that part one's not is because part two says it. Part two delineates and specifically says that they committed, you see it, the defendants committed overt acts to affect the object of the conspiracy, which include acts of racketeering as described below. So, and this is no offense to anybody, but I think it's disingenuous to say that, or it ignores the language of the statute. Let me just say that, or the indictment itself, to say that we don't know whether or not the part one is also the overt acts and the predicate acts, because the indictment, while it could be better and it could specify which one of the overt acts are racketeering activity, definitely it could, and it doesn't. It does delineate what acts we are saying are or could be or they might have to defend against. And then when you look to the statute, it is further limited. Not every act is going to, for example, the money transfers. Those are overt acts in furtherance of the conspiracy, allegedly. That's what we say they are. However, that in no way falls within any definition. It doesn't fall within the statute. It's not an arson. I mean, it's not related to arson, or it's not related to murder, robbery, kidnapping. It's not an act or threat. It's not with one of the one of the crimes, I need to slow down, one of the crimes under the 5A. And so, no, I mean, but it does require that analysis. So the state's position, Judge, is what I've said. And then, as far as whether or not there are other aspects, one of the things that they have alleged is that we have not drawn enough, or we haven't alleged, and they're saying in different ways, but one of the arguments is, and Mr. Samuels said it, and I think it's been said multiple times, is they don't even say for example, they don't say my client did an overt act, or excuse me, did a predicate offense. He or she is not charged, or they is not charged in this crime or that crime. And I'll just say, Judge, we don't have to allege or prove that, we'll go back to Mr. Liberto since he's been the star of the day, that Mr. Liberto or any particular defendant charged in this indictment, we do not have to allege or prove that they ever committed a predicate act, or that they ever agreed to commit a predicate act. And bear with me, Salinas v. State, and I know I should have proved, Salinas v. State, excuse me, Salinas versus United States. And that is 522. And I do have a copy of any of these you want.
522.
US 52. Figure out what page that is. 1 second, Judge, I need to direct you to the page. Thank you. Sorry, Judge, for the delay. Another yellow. Distinguished case. Just want to make sure I reference the correct page number. It's going to be it's gonna start, Judge, I think on 62. Get to the correct quote. If conspirators have a plan. So, there's a portion of it, Judge, that quotes to United States v. Holt, and that's 236 U.S. 140. And the Salinas Supreme Court says, if conspirators have a plan which calls for some conspirators to perpetrate the crime and others to provide support, the supporters are as guilty as the perpetrators. As Justice Holmes observed, plainly, a person may conspire for the commission of a crime by a third person. A person, moreover, may be liable for a conspiracy even though he was incapable of committing the substantive offense. And that's cited to Rabinovich.
I don't see that on page 62.
I may have that on page, not it.
Conspiracy may exist even if the conspirator does not agree to commit each and every part of the substantive offense. The partners in the criminal plan must agree to pursue the same criminal objective and may divide up the work. Each is responsible for the acts of the other.
Yes, sir.
If conspiracy of the plan which calls for some conspirators to perpetrate the plan and others to provide support. The supporters are as guilty as the perpetrators.
Yes.
Finally, a person may conspire for the commission of a crime by a third person. The person, moreover, may be liable for conspiracy even though he is incapable of committing a substantive offense.
That's page 63 to 64, Judge, so yes, I apologize. And continuing on, in that same case, Judge, it rejects the concept, in fact, they argue in this case, that we should have to prove that connection, that each perpetrator or each defendant, was required to have participated or intended to participate, to engage in or commit racketeering activity. And the court directly rejected that. And let's see, on page 65, towards the bottom, it says a conspirator must intend to further an endeavor which, if completed, would satisfy all of the elements of a substantive criminal offense under the federal statute, which is different from ours. But it suffices that he adopt the goal of furthering or facilitating the criminal behavior. He may do so in any number of ways, short of agreeing to undertake all of the acts necessary for the crime's completion. One may be a conspirator by agreeing to facilitate only some acts leading to the substantive offense. It is elementary that the conspiracy may exist and be punished whether or not the substantive crime even ensues, because conspiracy is the distinct evil dangerous to the public. And this is where, in the state's opinion, it has particular pertinence to their argument. It says it makes no difference whether that the substance offenses under the federal statute requires 2 or more predicate acts. The interplay between subsections C and D does not permit us to excuse, that's the conspiracy aspect of it, does not permit us to excuse from the reach of the conspiracy provision an actor who does not himself commit or agree to commit 2 or more predicate acts requisite to the underlying offense. So again, addressing the argument being that we had to allege in our indictment that the defendants either agreed to commit acts, predicate acts, or did commit predicate acts, that's incorrect. We do not have to make that accusation in the indictment. We do not have to allege that. We do not have to prove that. As long as they knowingly joined the conspiracy, and the conspiracy itself has the common purpose of committing racketeering activity, and I quoted that to you earlier, or cited that to you earlier. In addition, I cited Thompson v. State to you earlier, which also supplies further, makes the state's argument even more secure or more definite, because it does not require, that's the case, Judge, that if you recall, and this is an important thing, we don't even have to prove that they had every knowledge, were involved in everything, that they knew all the facets of it, that they knew what all of the co-conspirators were going to do. As stated, what we must prove is that they intended and knowingly joined the conspiracy, and that the conspiracy had the common purpose. And that's what we have to prove, and we have explicitly alleged that in paragraph A of the introduction. So, as to that argument from the defense, it just doesn't pan out, Judge. They also argue that the criminal purpose to commit, that we have to allege and prove that the enterprise had a criminal purpose, and that, I don't know how much this was fleshed out in oral argument, but I saw it in the written, that the enterprise must have a criminal purpose, and that's just not an accurate reflection of the law. The law that I have cited to you already and read in court already explains that an enterprise isn't a crime itself, and that it doesn't have to be criminal. I mean, the enterprise, this grouping of individuals associated in fact, can be, in fact, illicit or illicit. So, and their activities can be licit and illicit. So the enterprise itself does not have to be a criminal, does not have to have a, in other words, they have to have the common purpose of committing, we have to prove, and we have alleged,
Wait,
yes, sir.
Licit versus illicit. Licit is, we've incorporated, defended Atlanta Forest, we are an enterprise. Illicit is, we're just a group of folks. There still has to be a criminal intent there.
Not an adjoining, not, they have to have a common purpose. And yes, as a group, as an enterprise,
And as long as that common purpose is a legal, legitimate thing, that's okay, right?
until this group of associates conspires and determines to, or agrees to commit 2 or more predicate acts to reach their objective. Yes, then now we're getting into the RICO, and that's what's alleged.
So they commit criminal acts.
Yes, yes, sir. Took me a minute to get there, but yes, sir. So I've already talked about the nexus. I've already talked about that. If you would give me 1 second, Judge, I want to make sure. There's a lot of argument, and I read the and I'm not going to go through every single one, but there is a lot of argument about there's not enough here, there's too much there, there's not enough here, there's not enough there. For example, night of rage, or whatever it may be. The reality of it is, Judge, we have to allege sufficiently the elements of the offense, which obviously for the last several hours I have been arguing that we have. We do not have to allege every fact that they want to know. We do not have to allege how we are going to prove something. We do not. That is, we give it, we allege the elements enough so that they understand what's coming in, or the charges against them, and that's really the point, and the charges they're going to have to defend against. And then the discovery, it shows them the evidence we're going to use. How we're going to use it and apply that evidence, what we're going to argue, what our internal mental thought processes are on prosecutors as to what evidence pertains to this and how we're going to prove that, that is simply not required in an indictment. And I'll give you an example, night of rage. They came down here for a night of rage. If we had gone into the definition and explanation and all the explanation about what a night of rage was, one, it would have no bearing on the fact that that was the overt act was alleged, that they came down on a night of rage, which the evidence will explain at trial, and they did X, Y, and Z. If we had gone through 15 paragraphs talking about this night of rage and where it came from and how we know they called it and all the calls to do it and all the things that different co-conspirators, named and unnamed, put out there on social media to stir up and then stir violence, then we'd have been talking about political violence again, or rhetoric again. So it's not necessary. We made an allegation of an overt act in furtherance of the conspiracy, and that's what we did. And there's no more detail that they're entitled to on those type of issues. So, I can't see all these. And Judge, I'll give you one last little example. I mean, I need to wrap it up, but the many things that they think they want to know are simply not required to be alleged in the indictment. I'll give you an example. Criminal trespass. The term criminal trespass. It says that so-and-so did commit a criminal trespass. And there's a lot of motions filed and people arguing about that. He's not charged with criminal trespass. It's listed as an overt act. Criminal trespass is not one of the offenses under 1614.3.5a. So it's not a criminal offense. It's not a racketeering activity under B. And so it's simply a statement, okay? Now, that he committed this in furtherance of. Could it be more specific? Sure. But is he entitled, because we use those words, to a full recitation of the elements of the offense? The state says no, because he's not charged with the offense. If we were charging him with criminal trespass,
But you couldn't charge him with the offense because it happened in
Yes.
DeKalb County.
true, but we're not. So we have not alleged criminal trespass in our indictment as a crime, and therefore, and again, what we're talking about is what is demurrable or not, or whether the indictment is valid or not. And that is not a valid basis to invalidate the indictment in the context that he's not charged with it. So the requirements that we set forth, every element of it, just does not pertain. We generally said that he committed criminal trespass. Now, they can argue whatever they want to the jury at that point, but that is one example. There are many others, but I think the court gets the gist of my argument, which is the details that are necessary, the details that define and prove or allege, not prove, allege, with sufficient particularity that the all of the elements, Mr. Garland did an excellent job of articulating those elements, that the indictment has done so, and that while it could be better, it is sufficient.
Okay. Your motion, Mr. Garland, you're up.
Okay. So even if we were to concede, which we don't, that the allegations of arson and domestic terrorism on January 21st satisfy general demur, that does not save this indictment from my special demur.
This count.
What?
This count or this indictment?
Doesn't save that, even if that was enough to save the indictment from a general demur, it doesn't save it from a special demur. Because the special demur doesn't identify those predicate acts in any way. And it doesn't tell us.
Are we talking about counts 2, 3,
It's
1?
counts with respect to Mr. Carroll.
Mr. Schwartz, he's up.
Counts
You
after.
delineated him, he's your guy.
Yes, sir.
Yeah, no, I understand what you're saying, Your Honor. There's counts 2 through.
There's 2 and 3. There's 1, 2, and 3. That's all we
Yeah,
got.
so counts 2 and 3,
Uh-huh.
which allege arson and domestic terrorism.
Yep.
There's an argument under which those could.
Right now, we're talking about count 1 in this motion. In motion number 3, right?
I'll abandon that because it's not essential to what I'm trying to convey, is that this indictment fails a special demur. State v. Eastman tells us
Count 1, because that's the motion I'm looking at. Count 1
count 1 of this indictment
does not
fails.
survive a special demur.
That's correct. And this is State v. Eastman, 911 Southeast 2nd, 484. It's a 2025 case. By filing a special demur, the accused claims not that the charge in the indictment is fatally defective and incapable of supporting a conviction, as would be asserted by general demur, but rather that the charge is imperfect as to form or that the accused is entitled to more information. That's what I'm focused on, Your Honor. The state, and the information we need is set out in the OCGA 17-7-54 and by Kimbrough. We gotta have the essential elements. It's got to allege the underlying facts with enough detail to sufficiently apprise the defendant of what he must be prepared to meet. And it must allow the defendant to prepare her defense intelligently. So they've got to allege that. They don't necessarily have to do it as a separate count in the indictment, but they've got to do it in the indictment. They can't get up here and argue that they're somehow met. It has to be in the indictment. They've got to allege the essential elements and the facts supporting them. And they fail to do that for many of the potential predicate acts that we've discussed today. Assault, influencing a witness, obstruction, money laundering, and whatever other predicate act the state can dream of.
Can you help me on the quote on the site for Eastman again?
Yes. 911, Southeast Second,
Give me the Georgia one.
okay, 374,
Uh-huh.
Georgia Ave,
Yep.
120.
Oh, even close.
Would you like me to pause, Your Honor?
Yeah.
Okay. And that's at page 121.
Okay, so you're saying, hey, these predicate acts that are criminal acts, I need my elements, et cetera, et cetera. Whereas I just heard from the state saying they're not charged with those, they don't have to give them the elements.
Well,
Because
I
they're
mean,
not charged with them, because they happen in another jurisdiction.
I think that's a red herring, Your Honor. I mean, Kimbrough and OCGA 17-7-54 are clear. We've got to state the essential elements. We've got to establish the underlying facts, right? It's required by Georgia law. It doesn't have to be in a separate count. It could be in the overt acts themselves. They could set out the essential elements. They could set out the essential facts, but they don't do that, Your Honor. They don't do it for assault, influencing a witness, obstruction, money laundering, and whatever else they can dream up. The discussion of Dorsey and these 5B acts, it's not a red herring, but they're putting the emphasis on the wrong syllable in that case. These 5B acts are acts involving murder, kidnapping, gambling, arson, robbery, theft, so on and so forth. The list of crimes listed in 5B that could involve predicate acts involving those crimes. But Dorsey's interpretation of 5B is really just about how we count the predicate acts. It talks about that the acts involving style of predicate acts can be their own separate predicate acts. So a series of acts involving another crime, can all be separate predicate acts, right? So in Dorsey, you've got the murder, right? That's one act. But then getting in the car, that's another act. Buying the gun, that's another act. These are all predicate acts under 5B. But what Dorsey has, that this indictment fails, is an allegation of the essential elements of the murder. Is an allegation of the essential facts supporting those elements, right? Dorsey is like, how many predicate acts are there in a murder, Judge? Well, we've got the murder, and then we've got the other acts involving it. But got that murder, it's proved, it's alleged, that essential elements are alleged, and the facts supporting it are alleged. We've got it, right, in the case. How do we chop it up? That's what Dorsey's about. Here, we don't have the essential elements. We don't have the facts. There's nothing to chop up. We don't know what these acts are involving. They haven't identified them. They haven't set out the elements as required. They haven't set out the facts supporting it. So Dorsey is not a problem for this demur. Had my complaint been there's too many predicate acts, well then Dorsey would be a problem for us. But that's not my complaint. Is that they haven't sufficiently alleged the predicate acts at all. And they clearly did that in Dorsey without a problem. They established elements, they put the elements of murder in and the facts supporting them. So it provides no problem for our special demur. There was some discussion by the state about the allegations in part 1 of the enterprise. I've already discussed how it's both overbroad and lacks sufficient details, but as we've discussed, are those allegations of predicate acts because they're specifically incorporated into the overt acts that include the racketeering acts per the indictment? Does it include George Floyd? Does it include Rayshard Brooks? Does it include the masked man was he involved in an act involving felony obstruction? We don't know. We can't know. The indictment doesn't tell us. And in regards, let's see. And I mean, there are certainly things that this indictment doesn't allege that I want to know. And it doesn't have to allege everything I want to know, Judge. But it's got to get across some fundamental threshold so I can prepare a defense for my client. This indictment is a problem of the state's creation. It suffers as a result of how they drafted an indictment. Georgia law prevents my client and all the other co-defendants from having to fight for their liberty based on an unintelligible indictment. And we ask Your Honor to grant this special warrant.
All right, ladies and gentlemen, it is 4:45. See you tomorrow. Before we go, I know, Mr. Daisner, you were making some noise over there. Well, I mean, something next, it was my intent. Number 4 was the lack of prosecutorial authority.
Your Honor, I can wait till number 10. Wordless for number 10.
Hey, look fun, that's what y'all put the list together.
Yes.
Okay.
Thank you.
Everybody wants to go fun a lot. See you tomorrow.
Tomorrow, 9:30, Judge, same time, same place?
Same bad time.